Yes, Judge. So I'll begin, please, by reading out a statement, and I confirm that the counsels are already on the line. The appeal hearing is in the matter of CA 013-2021 before Chief Justice Zaki Azmi, His Excellency Justice Ali Al-Madhani, and Justice Robert French, and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The appellant is represented by Charles Russell Speechlys, LLP. Lead counsel is Stephen Doherty. The respondents are represented by Onoma Abdadi. Lead counsel is Stephen Thompson, QC, assisted by Faisal Osman.
Okay, yes. Can we begin, Mr. Doherty?
Yes, thank you, my lord.
Did I pronounce your name correctly? I always worry about pronunciation.
You did. Thank you.
Okay, thank you.
Good morning. As you'll have gathered, this is an appeal from a decision of Justice Giles on the 22nd of August last year. On 1st of November last year, Justice Giles granted the appellant permission to appeal on the three grounds that I'll address your lordships on today. This court has also granted permission to appeal on a further ground, which isn't the subject of today's hearing, but is due to be listed in the coming weeks and months. So, my lords, the grounds of appeal under consideration today are in the bundle at tab 1, page 4.
Mr. Doherty, before we proceed on, I think my brother, Judge Robert, has something to say. Robert, would you like to put your what we were discussing to the parties, see whether they can? Yes, I leave it to you, Robert, please. Robert, you're muted. You're muted, Robert. You're muted.
I thought I'd cured myself.
Yeah, okay. Yes, Robert.
Mr. Doherty and Mr. Thompson, we've had the opportunity of reading, of course, your extensive skeleton arguments and of course, the judgment of the primary judge. And I note also the respondent's supplemental argument, which has been lodged, was it yesterday or the day before? There's some objection raised to that, but really, before I read the respondent's supplemental skeleton argument, it did seem to me that when all was said and done, this case does reduce to the central single question whether the shareholders had the authority to deal with the property of the company, and in particular, whether they would have had the authority to execute the tenancy agreement. If they did not have that authority, then the question arises, how can they authorize somebody else to do what they themselves could not do? Now, if that is the central question, then issues about Geomatic and the background and nature of the transaction tend to fall away to some extent. And speaking for myself, I would be greatly assisted by, first of all, the consideration of why that isn't the central question, if it isn't, and then secondly, what's the appropriate approach to it.
Yes, my lord, I'm very grateful. It's close to being what we say is the central issue. The question isn't so much whether a shareholder or a beneficial owner has some proprietary interest in property which they are then able to dispose of as they please. That is, in my submission, a settled question. It's something which arises from the long line of authorities in Salomon and has been dealt with in more recent cases like Singularis and those authorities which deal with questions of reflective loss. The issue in this case is slightly different. It's about when the acts of shareholders become binding acts which are directly attributable to the company and therefore bind the company in it dealing with its own property. So it's a slightly distinct issue. And so we say that the question isn't really addressed by the issues raised in the supplemental skeleton, and it's something which is addressed by the line of authorities from Salomon onwards, but which come to Geomatic and then the subsequent cases in the 21st century. And we say they're effectively three building blocks on those lines of cases which get us to the answer that the court needs in this case, which is, first, what is the proper extent of the geomatic principle? Secondly, does that principle mean that the acts of shareholders, when unanimous, become direct and binding acts of the company, including with respect to third parties? And then the third question is the issue of agency and whether that principle can be extended on the application of law of agency so that another authorised third party can undertake those acts.
So what could the shareholders in this case, of it's Majid and Madhani, have done in a formal way that is rescued from informality by Geomatic?
They could bind the company in entering into the tenancy agreement.
Do you mean they could enter into the tenancy agreement?
We say that at the point in time at which there is, or is to be taken as being, informal assent to the entry into the tenancy agreement by the shareholders, that is the point in time at which the company is bound by it. So it isn't an execution issue. It's on our analysis, the tenancy agreement is effective at the point at which it's signed by Abdullah. And I can take you through the authorities and why we say that's the case.
Okay, before you proceed on, where did Abdullah derive this power to sign that agreement? There are two powers. One is a director. He's a director, he signs as the director. If it is a shareholder, he signs as a shareholder at the AGM, at the general meeting, not annual general, at the general meeting of shareholders. The shareholders have powers at the general meeting of shareholders, or the directors have powers at the board of directors. Isn't that? Do you agree with me there?
I would agree that those are the normal ways in which a company operates. That the effect of the geomatic principle is another primary rule of attribution, which means that in circumstances where you have assent of all of the shareholders, including informal assent, that becomes as binding an act on the company as it would be.
Implied authority.
No, it's not a question of implied authority there. There's express authority, which is why Abdullah acts in the way he does in this case. The issue of how the tenancy agreement becomes binding is a slightly different analysis, and that has to do with the rules of attribution of company acts. And what we say the law says there is that informal actions of all of the shareholders are binding acts of the company in the same way as a board of directors operating under company's articles can bind the company. So that's our position.
I must confess, I'm not familiar with the rules of attribution. I'm not familiar with that at all. I must confess that. I don't understand what is rules of attribution. Perhaps for myself, for me, I don't know, the other two judges may be familiar, but for me, could you expand on what is rules of attribution means?
Yes, I'm happy to do that. I think it would probably assist if I go first of all to the background in Geomatic and how that then interrelates to attribution. So, as I say, the appellant submissions are effectively built up in 3 stages. The first is Geomatic, which is the basic statement of principle that the unanimous agreement of shareholders is an act which is binding on the company. That then ties into the second point, which we rely on, which is to say that the Geomatic principle read together with these rules on attribution, which are derived from a case called Meridian, which I'll take you to, mean that when shareholders act in concert in that way, it is as binding on a company as it would have been if a board of directors had acted in the way that they were authorized to act under the company's articles. So that's second point. And the third point is then when we get to this agency question, which is what does the power of attorney say, and does it mean that Abdullah could stand in the shoes of the shareholders in order to do whatever they could do?
But this only works, doesn't it, Mr. Doherty, if the unanimous agreement of the shareholders is an agreement about something which they had power to agree upon?
Yes, we agree, and that's where the second building block comes in.
Power is the question. Geomatic doesn't create power so much as rescue from informality.
No, but what we say is that the law on attribution does mean that shareholders have the power to do anything which a company under its memorandum can do. So in this case, the company had the power to deal with its own property, and that the shareholders can do anything that the company can do, provided that there is unanimous shareholder assent to it. And we say that that is derived from the authorities on Geomatic, which is obviously really an authority following on from Salomon, as well as the attribution authority, so Meridian and others.
Have you got any authority which tells us of a case in which shareholders have authorised the sale of company property and thus bound the company?
Yeah, so one case I'm going to take you to is Express Engineering. It's an early 20th century authority.
Gave effect to the sale or disposition of company property without the directors being in.
Yes, so I'll come to it obviously in more detail, but what we say that case is authority for is that the directors in that case were precluded from acting because they were conflicted in the decision making.
Well, that wasn't this case.
No, that isn't this case, but the point of principle is that the point at which the transaction, so in that case, it's the purchase of real property in exchange for the issuance of debentures, became an effective act of the company at the point in time which the shareholders met and decided upon it. But as I say, I can come on to that in more detail. Effectively, as a broader structure, what I propose to do is to take your lordships to the law on Salomon, Geomatic, and so on, and then I'll come back at the end to address you on the grounds of appeal themselves in the context of those submissions, because I think really at the core of this case is the legal issue. Before I come on to those legal issues, I know your lordships have had the opportunity to read. I'm happy to provide a short summary of the facts if it would assist, but if you're content with those, I'm happy to move on straight to the issues of law.
Yes, please.
Move on, please.
Thank you.
As you submit on law, you can refer to the relevant facts, so that we.
Yes.
Okay, good. Yes, please.
As I say, there are effectively three building blocks to what the appellant's case is, and I've taken you through those. And as I say, once those points are established, hopefully it will explain why it is that we say respectfully Justice Childs was wrong in his conclusions. The starting point for that on the law probably is going to be the well-known decision in Salomon, which your lordship should find at tab 9, page 1.
Solomon against Solomon?
Yes. So it's the classic authority cited in reference to the distinct legal identity.
If you have done a company law and you have not heard of Solomon against Solomon, there's something wrong with you.
So of course. So it's at tab 9, page 36, I think, which is the which is the basic statement of the principle. So this is from Lord Davies' judgment, and it's in the second to last paragraph of page 936. But what he says here, which is the point which is raised in Geomatic and a whole host of other cases, is that I think an inevitable inference from the circumstances of the case that if every member of the company assented to the purchase and the company is bound in a matter inter vires by the unanimous agreement of its members, and then says, in fact, it's impossible to say who was defrauded. So that is the relevant principle from Solomon. Just pausing there for a moment, I note that Junior Counsel for the respondents made a number of additional points about Solomon and his skeleton. That's it, paragraphs 35 to 44, essentially to the effect that Solomon establishes the distinct legal identity of companies separate from their shareholders, and that shareholders have no proprietary rights over the property of a company. And in doing so, he also refers to the well-known judgment in Macora, which is about whether a shareholder could insure an asset which belonged to a company. I should just say that I don't think that there's anything controversial in any of that. This isn't really a case which engages those principles. So, as I said at the outset, this isn't a case about the rule against reflective loss, for example, because it's not one where the appellant is saying that the shareholders beneficially owned the London properties. The issue in this case is different. It's not about who owns the company's assets, but it's about whose acts are capable of becoming binding acts which are attributable to a company. And we say that Geomatic and the other related cases give us the answer to that. So if you move forward 2 pages in the bundle, we should hopefully find the beginning of the judgment in Geomatic. The facts of the case aren't so important as the principle. Essentially, it was an action brought by liquidators seeking repayments of sums that were paid out to 2 directors who, at the time the payments were approved, were also the only ordinary shareholders who had voting power in the company. And it was common ground in that case that the payments weren't authorised by a company resolution in a general meeting. And the argument before the court was that that didn't matter because all of that fell away because the only shareholders with voting rights had approved the payments. And the agreement or the assent in that case was by the shareholders drawing up and approving the company accounts, which made reference to the director's remuneration.
And they could have passed a resolution to that effect.
Yes. So the facts I've referred to for your reference there at 372E at the judgment, but what I want to refer you to is at page 46 of tab 9. At the top of the page, which is the classic statement that is always lifted from Geomatic on this question of principle, and is one which was referred to by Justice Giles in his judgment. It's the passage beginning with, "It seems to me that if it had occurred to Mr. Elvins and Mr. East at the time they were considering the accounts to take the formal step of constituting themselves a general meeting of the company and passing a formal resolution approving the payments of director salaries, that it would have made the position of the directors who received the remuneration secure, and nobody could thereafter have disputed their right to retain the remuneration. The fact they did not take that formal step, but they nevertheless did apply their minds to the question, seems to lead to the conclusion that I ought to regard their consent as being tantamount to a resolution of the general meeting of the company. In other words, I proceed upon the basis that where it can be shown that all shareholders who have a right to attend and vote at a general meeting of the company assent to some matter which a general meeting of the company could carry into effect, that assent is as binding as a resolution in a general meeting would be." Pausing there, first of all, the appellant notes a few points. The first, which is perhaps an obvious point, is that the Geomatic principle, as I'll refer to it, is to a large extent concerned with holding a company bound by the agreement of its shareholders in a way that negates formalities, which otherwise would have been required under the company's constitutional documents. In our submission, it would be a mistake to take that principle and reject its application on the basis that the way that the tenancy agreement was entered into conflicted with the company's articles. We say that places an undue emphasis on formality in a way that acts to undercut the purpose of the principle.
Well, there's a distinction to be drawn between formal requirements and the definitions of the limit of power.
There may be in some circumstances, our cases, that where you have unanimous agreement of the shareholders, that isn't necessarily the case. I will come on to explain that.
Can the shareholders bootstrap themselves up into a position to exercise a power which they wouldn't have simply because they unanimously agree?
The scope of what the shareholders can do following the line of authorities, which we'll go through, is anything that's authorised under, excuse me, anything authorised under the company's memorandum. So if it is business that the company can engage in, the shareholders can bind the company in that business by acting unanimously. And we say that that's a rule of law.
Yes.
The second point on Geomatic, very briefly, is that it's immaterial in this context that the act of the shareholders in effect means that the company is parting with its property or altering its position in some ways. So one of the points relied on by the respondents is to say that the London properties belong to the BVI companies and the shareholders have no right to deal in them. So that's the Macora line of authority. Well, we say that misses the point because Geomatic was also a case where the unanimous agreement of shareholders leads to the company giving up certain of its proprietary rights, albeit in this case making cash payments rather than transferring a piece of real property or an interest in a piece of real property, as would be the case here. And as I've already said, the issue isn't whether the shareholders had the proprietary right to deal with the assets, but whether the shareholders acting unanimously can bind the company as a distinct legal entity. A third important point we say...
Sorry, there's a distinction between the proposition that the shareholders have proprietary rights, which they don't have, and the question whether the shareholders have power to do certain things.
Yes, correct.
And what we're concerned about here is whether there is power, and you say if there isn't, somehow it is overcome by a doctrine of attribution derived from Geomatic and the proposition that anything they could agree to could be done by could be attributed, that anything the company could do, they could do by unanimous agreement.
Yes, so we wouldn't say it's the case of the shareholders not having the power, simply that the power derives from a number of primary sources. So from the director's perspective, their power to act for the company in personam is derived from the Articles of Association. Yeah. But there is also a rule of law which says that the shareholders acting unanimously have the power to do the same thing, provided it's within the context of the company's...
You're not pushing against a proposition that the shareholders have proprietary rights. That's not what you have to deal with.
No, absolutely not. Thank you. And a third important point we say arises when one follows through on the judge's reasoning in Geomatic. So if we go back a couple of pages to 943, which is page 370 of the judgment. This is the beginning of the judge's reasoning. It's Buckley, and beginning at F on that page, we can see that he refers to another case from 1920 in Re-Express Engineering Works Limited. And in that last paragraph, Justice Buckley sets out a summary of the facts of that case. Effectively, what happens is that 5 individuals purchase some piece of real property for £7,000, and a couple of days later, they sell it to the company for £15,000, so a little over double that amount. The contract for the sale of the company, and this is a G, and the issue of the debentures was carried out at a meeting of the 5 individuals who thereupon appointed themselves as directors of the company. And their case was that effectively constituted the first board meeting of the company at which the acts were approved. And if we go over the page to 371, we find that the judge refers to a couple of extracts from Express Engineering Works, which I'm going to park for the moment because I'm going to take your lordships to that case itself. But as we scroll down the page to H, we see the statement of principle that's being relied upon from that case. So it's saying in that case there were no non-voting shares, but Mr. McCulloch contends that the presence of the non-voting shares in the present case does not matter if he can establish that those who were entitled to attend and vote at general meetings of the company in fact agreed to all or any of these payments. Then he says that's tantamount to a resolution passed at a general meeting of the company, and that the agreement of those persons is binding on the company in the same way as a resolution of the general meeting is binding on the company. And over the page again, we have reference to another earlier line of authority, Parker and Cooper. I don't intend to take your lordships to that case, but you'll see from C of this judgment, that case is what's being relied upon to say that it's immaterial whether the consent of the corporators is obtained at the same time or different times in order to give its consent to a particular transaction. So that's to do with the informality aspect of the issue. And the important point is that if one then follows that through to the next page, is where we get that classic statement at 373 from Buckley of what is now termed the geomatic principle. So it's derived from these two cases, Express Engineering and Parker and Cooper. And with that in mind, I take your lordships directly to the Express Engineering decision, which we say throws up some important points of principles, which clearly weren't doubted when the reasoning was formed in Geomatic, and that's at tab 13, page 1. As I say, the facts were already summarised in Geomatic, but it's 5 individuals sell the property they'd acquired a couple of days earlier for twice what they paid for it. The consideration for that transaction is the issuance of debentures back to the 5 individuals. And the guise under which that transaction was effected is that the individuals say they appointed themselves as directors and that the transaction was effected through a board meeting. However, the point taken by the other side in Express Engineering was that that action was precluded by the fact that the company's articles prevented directors from voting in respect of transactions where they were an interested party. And so the Court of Appeal's rationale as to how the transaction was executed becomes important in the context of this case. So first of all, if you go to page 470 of that judgment, this is first of all the judgment of Lord Sterndale.
Okay, can you give me the bundle page, please? What page of the bundle? Your bundle?
So it's tab 13, page
13.
It should be page 5.
Yeah.
13-5, is that it? 13-5.
Yes.
Okay. At page 470.
That's right.
Okay, good.
And the bit that I'm referring to is in the second paragraph. So it's Lord Sterndale referring back to a previous authority case in re George Newman and Co. And what he's saying here is that there are differences between that case and the present one. First, the transaction there, so that's a reference to the Newman case, was ultra vires. And secondly, in that case, there was never a meeting of the corporators. And what he says is that in the present case, these 5 persons were all corporators of the company, and they did all meet and did all agree that these debentures should be issued. Therefore, it seems that the case came within the meaning of what was said by Lord Davy and Solomon, which is the extract I took your lordships to earlier. So, as a reminder, the context of this case, the court was dealing with the question of whether a transaction to purchase property and issue debentures was capable of being entered into by the corporators, i.e. the shareholders, in circumstances where they weren't able to make that decision as directors because the articles precluded them from doing so. And what Lord Sterndale is saying is that the transaction could be given effect by the corporators, and that is something which is consistent with the line of authority derived from Solomon. Moving on in the judgments at the bottom
But
of
in
the same page.
Geomatic, was there a third party involved? Like here, there is a third party involving the liquidators. But is there receivers and liquidators, Mr. Prevok or something like that? But in Geomatic, what's the fact again? Can you remind who was contesting or who was challenging this decision in Geomatic?
Well, in Geomatic, the transaction I think was being revisited by the liquidators.
Yeah, but who were liquidators acting for?
I think they were acting for the company, saying that the money should not have been paid out by the company because it wasn't authorized.
There was no bank or somebody who's interested to have.
I suppose one would assume that there were creditors on whose interests the liquidators would have been acting.
Okay.
Moving then to what Lord Warrington says about the same case in Express Engineering. So this starts at the bottom of page 370. He says that it happened that these 5 directors were the only shareholders of the company, and it is admitted that the 5 acting together as shareholders could have issued these debentures.
That was a concession, was it?
That seems to be how it's framed, but it certainly doesn't seem to have been questioned by the court. And as directors, they could not, but as shareholders acting together, they could have made the agreement in question. It was competent to them to waive all formalities. Sorry, this is going over the page. It was competent to them to waive all formalities with regards to notice of meetings, etc., and to resolve themselves into a meeting of shareholders and unanimously pass the resolution in question, inasmuch as they could not, in one capacity, effectually do what was required, but could do it in another. So that's a reference to them not being able to do it as directors, but then being able to do it as shareholders. It is to be assumed that as businessmen they would act in the capacity in which they had power to act. In my judgment, they must be held to have acted as shareholders and not as directors, and the transaction must be treated as good, as if every formality had been carried out. I agree that the appeal should be dismissed. So,
Mr. Doughty, I got this principle in Geomatic, or in Express Engineering. Can you take these facts of Express Engineering and put it against the facts before us, the facts of the case before us? How do you are saying that there is one shareholder or two shareholders, 2 companies, one in is it Cayman, and the other one is BVI. One is BVI, and the other one is. Can you take these facts and put it against the facts before us and do a comparison?
Yes. So in this case, the transaction is between BVI companies and third parties. So it's Igpl and a number of other natural persons. Yes. And what the analysis the appellant contends for in this case is that the 2 shareholders of the BVI companies could, if they had both assented or both agreed or were acting together, have taken steps to bind the BVI companies in entering into the tenancy agreement with third parties. And the reason for that arises from this line of cases which arise after Solomon and even precede Geomatic. And we can see that I don't want to use the word authority because I'm going to come on to authority in a different context later, but that power exists as a matter of law, as we can see in this Express Engineering case. So the way the court is framing this issue here is that the action of the company is being directly affected by the acts of the shareholders in circumstances where the directors or the same individuals as directors were conflicted and therefore were prohibited by the company's articles from acting. And so the main point of principle arising is that the unanimous act of the shareholders, in this case, in Express Engineering, stands as an act of the company without the involvement of its executive arm. So without it acting through the directors, because they couldn't act. And we say that that principle is carried across in all three of the judge's reasoning. So looking at page 471, continuing with Lord Younger's judgment, this is in the middle of the page. He says, I'm the same opinion. I am content to rest my conclusion upon what Lord Davy said in Salomon's case, that a company is bound by a matter which is inter vires by the unanimous agreement of all the corporators. So it's not that the company's directors are bound to follow the unanimous agreement of the corporators. It says that the company is bound in a matter by the unanimous agreement of its corporators. And he says that no fraud is alleged in respect to this transaction. And then this bit is important too. It seems to me that the effect of the resolution of March 11th was that the company, by the voice of all of its shareholders, became bound by this agreement. So the point at which the act becomes binding upon the company, as though it were an act of the company, is the point at which the shareholders have got together and are taken to have assented to the course of conduct.
How does that compare with our case? Was there a decision by the shareholders? Whether there was a decision by the shareholders?
Well, yes, we say that there is that decision, and that decision is one which was made by conferring authority on another individual with express authority.
No, the decision was implied by the fact that the shareholders agreed, or no, there was no objection, and therefore there was an implied. Because earlier on in the express, the judge said, what did he say? He said, doesn't matter whether as businessmen they choose the best, they would have deemed to have taken. I think it have inference from the circumstance of the case that every member of company assented to the purchase, and the company is bound in a matter inter vires in anonymous decision. It is true that a different question there, but I'm of opinion that this case, it has been said that it has been said that the meeting was a directors' meeting and might be well considered a general meeting or the meeting of the company. For although it was referred in the meeting as a board meeting, yet if 5% present had said, we will now constitute a general meeting, it would have been within the powers to do so, and it would have appears to have been the fact what they did. You see, even though there was no general meeting, because these are the same people who are shareholders and who are directors, so even if they sit together, the judge is saying that I'll treat that as equivalent to a general meeting. Right? That's what the judge said in the express. But how does that happen? Did that happen in our case, in the present case? Because it's all decided by one person. Abdullah decided everything.
Yes, so
he was the AGM, he was the general meeting, he was the director, he derived his power of attorney. But the other question that was posed to you by Judge French was, he had the power attorney. Where did he derive that power attorney? Who gave him that power attorney? Did the person who gave the power attorney have the power to convey that power to Abdullah?
Yes, I will come on to that issue in due course on the authority issue. But just pausing very briefly on the question of principle, it's not only that this decision has the effect of saying that you waive the formality of a general meeting, but the other point of principle to be derived is that it's in the act of assenting or the act of agreeing unanimously by the shareholders that the act also becomes a binding act of the company. So that's the other important aspect of this. So the authority that we derive from this case is to counter the suggestion by the respondents that the only thing the shareholders can do is club together and ask or effectively require the directors to go off and take some formal steps to execute something. What we say is that the unanimous agreement of the shareholders is the act of the company itself, and that doesn't require then the formal ratification by the directors. And that actually brings us on quite neatly to this second building block, as I termed it. So the issue of attributability. The Geomatic principle has the effect that where shareholders are unanimously agreed, that becomes an act which is attributable to the company. And we say that's the clear logical effect of what we've just set out in express engineering. But it's also something which has been described in more recent cases. And I referenced earlier the Meridian Global Funds Management and Securities Commission. Your Lordships can find that case in tab 9, page 51, I hope.
9-51. Okay. Read in Google Fonts.
And what I'll do is I'll usher you immediately forward. So this is part of the judgment of Lord Hoffman, but I'm looking at page 506 of the judgment, which is page 57 of that tab. And this is where Lord Hoffman is addressing rules of attribution and the legal principles that apply in relation to how a company acts through its natural persons. I'll apologise in advance because it is quite a long extract, but I think it is important to go through it in full. But it's the paragraph beginning with B in the margins, who said that any proposition about a company necessarily involves a reference to a set of rules. A company exists because there is a rule which says that persona ficta shall be deemed to exist and to have certain powers, rights, and duties of a natural person. But there would be little sense in deeming such a persona ficta to exist unless there were also rules to tell one what acts were to count as acts of the company. It is therefore a necessary part of corporate personality that there should be rules by which acts are attributed to the company, and these may be called rules of attribution.
Okay.
And what he says is that the company's primary rules of attribution will generally be found in its constitution, typically the Articles of Association, and will say things like the purpose of appointing a member of the board, majority of the shareholders shall be a decision of the company, or the decisions of the board in managing the company's business shall be the decisions of the company. So that's effectively the respondent's position. That's how a company normally operates. What Lord Hoffman then says is that there are also primary rules of attribution, which are not expressly stated in the articles, but implied by company law, such as, and then this is effectively a statement of Geomatic, but it's the one that's formulated in the multinational gas case, which both parties have referred to in their skeletons. And that says that the unanimous decision of all the shareholders in a solvent company about anything which the company, under its memorandum of association, has power to do, shall be the decision of the company. And he then goes on to say that these primary rules of attribution are obviously not enough to enable a company to go out into the world and do business. Not every act can be expected to be subject to a resolution of the board or a unanimous decision of the shareholders. And he then goes on to explain what he refers to as the secondary rules of attribution. So that's where a company builds upon those primary rules by using the more general rules equally available to natural persons. So that's principles of agency. So the company can then appoint servants and agents whose acts become acts of the company. So what Lord Hoffman is talking about here is, as a matter of law, when an act becomes an act of the company, and that there are a number of ways in which a company can act. One, as I say, is what the respondent relies on. It's where the directors act in the way that they're authorised to act under the company's Articles of Association. One is through agency. So the company can have its agents who are not directors who can be appointed to act, and the reason for that is obviously pragmatic. A large company can't be expected to ratify every decision it makes through its board or through its shareholders, and so it has other servants who will be so authorised to act. But importantly, one of the other primary rules of attribution in law is the application of the Geomatic principle. And in this case, it's how it was framed in multinational gas, whereby the unanimous decision of all the shareholders about anything the company can do in its memorandum shall be the decision of the company. Put differently, unanimous shareholder acts are not acts that require further ratification or execution by the directors. They are acts of the company, and the shareholders can, acting in that way, do anything that the company is permitted to do in the company's memorandum. And following on from that reasoning in Meridian, those rules of attribution are not subsidiary to the powers of the directors in the Articles of Association. They stand alongside it as another primary rule of attribution. And we say that's not a novel argument. It's obviously one which has been addressed in Meridian. It's also one which seems to have been considered in the early 20th century in express engineering. It's also, for what it's worth, an argument that my learned friend relied upon when he appeared in Siban Management Corporation and Sitco, which is the next case that I take your lordships to.
Before you proceed, Mr. Doty, can you take these facts, the facts of our case now, and put it against the principles that was laid down by Lord Hoffman in this case, and how do they match the facts of our case?
Yes.
Are you saying that because there's one shareholder, or rather one person holding out?
There are two shareholders.
Two shareholders. So, I mean, yeah. Okay, yeah. Go on.
So there are two shareholders in this case. For reasons which I'll come to, those shareholders conferred a broad power authorizing another individual to sign on their behalf. But for the purposes of the present argument, let's hypothesize that the tenancy agreement was signed by Majid and Muhammad Al-Sari rather than Abdullah. So let's say that on the face of it, the tenancy agreement bears the signatures of both of the shareholders of the company. We say that that would stand as being the assent or the agreement of the shareholders to the BVI companies entering into the tenancy agreement. And following the line of cases in Salomon, in Express Engineering, and in Geomatic, which followed both of those cases, and indeed multinational gas, anything that the company could do in accordance with this memorandum of association, those shareholders also had the power to do when acting in concert and when acting unanimously. And so, at the point in time at which the shareholders assented or agreed, or are to be taken as having agreed to entering into the tenancy agreement, that became an act of the company. And because that was an act attributable to the company, it is a binding act, not only internally, but it is a binding act with respect to third parties. So the company is bound by that agreement in the same way as if its directors had entered into the agreement. And it's worth pointing, the execution issue in some ways is a bit of a red herring in this case, because of course, there are circumstances in which a company could enter into an oral agreement through its directors or, for example, through its shareholders on this analysis. So the actual signing of the document itself doesn't have any particular magic in it. It's accepted on the facts of this case that this agreement doesn't stand as a formal deed, for example. The analysis that it's an agreement to enter into a lease. So the execution isn't the important point. The important point is this agreement an act of the company which binds it to the outside world? And we say that on that analysis it does.
Mr. Doherty, as I understand it, the respondents don't dispute the principle that a decision by company members in a meeting is a corporate decision binding on the company, and they don't dispute that a duly appointed agent acting on behalf of shareholders could make that decision under a power of attorney. And they seem to accept, and Mr. Thompson will no doubt correct me if I'm wrong, that these were the consequences of Geomatic and later authorities, but they contend that a binding corporate decision by a company's shareholders does not mean that they have power to bind the company into a contractual commitment with a third party by assuming its proprietary rights over the assets. Now is that not the killing ground here?
That is the point of dispute between the parties. I suppose it potentially breaks down into two sub-issues there, which is one, can Geomatic bind a company with respect to outside parties? And we say it does. The second, I think, is a disagreement over how the case is framed, because we don't say that the shareholders assume proprietary rights over the property, but simply that they can direct the acts of the company, because the company always has to act in personam. It has to act through natural persons. And that one of the ways that it can act through natural persons is through unanimous shareholder assent. So it's not about proprietary interests. It's about who has the power to direct acts which are attributable to the company.
It's not about an assertion that they have proprietary rights. It's about a characterization of whether what they've done amounts to an assumption of the company's proprietary rights, isn't it? Or what they're said to have done, what's attributed to them.
That may well be the effect of what's happened, but that's the same with all of the Geomatic cases. When a company has been bound in Geomatic itself to pay out salaries to directors in a way that wasn't in accordance with the company's articles, that was still an act which had the effect of the company giving up its proprietary rights, so giving up cash in that case. So that's not, the effect of it is immaterial. The question of principle is, what can shareholders do in law to direct the acts of a company, and that the effect of that should have some impact on the company's position, or that it should affect some proprietary right of the company, doesn't matter. It's not assuming any proprietary rights on the part of the shareholders. This case doesn't involve Igpl saying that Majid or Mohammed had some equitable interest in the property. It's accepted that it remained the company's, and it was the company's to do with as it pleased in accordance with its memorandum. My lord, I was coming on to another way in which that same argument was presented in Siban Management Corporation and Sitco. That's in Bundle 9 at page 125.
Bundle 9 at page 9 dash
125.
125. Okay. Okay. Siban Management against Sitco.
This case, we say, touches on, I suppose, the tail end of our submissions on attributability, but also feeds into the next building block, which is the authority issue. By way of a brief summary of what this case was about, we have a Brazilian businessman, Mr. Byington, who attempts to arrange his affairs in such a way to shield his assets from creditors. And in order to do that, he acquires a BVI company called Spectacular Holdings, which he holds through bearer shares. And Spectacular, whose successor entity in this case was the claimant, appointed the defendants as a corporate director and registered agent. In practice, what happened was that Mr. Byington, so this is the ultimate beneficial owner and shareholder, had a long-standing acquaintance, Mr. Costa, who gave instructions to the defendants, so that's the director, requiring particular actions to be taken in relation to the companies. And that included instructing the issuance of various powers of attorney. And initially, those acts, at least, were known to Mr. Byington, the UBO. But the claim arises in this case because there's a falling out between Mr. Byington and Mr. Costa. Unbeknown to the shareholder, Mr. Costa then instructs the company to issue a power of attorney, which is then utilised to sell company assets, and he uses those funds to pay himself. So the claim is premised on various alleged breaches of fiduciary and tortious duties arising from Mr. Costa's fraudulent acts. And one of the central questions amongst a number in that case was whether the instruction given to Mr. Costa in relation to the issuance of that final power of attorney, which was used to defraud Mr. Byington, could be treated as an act that was attributable to the company. And so if we jump forward to page 130, which is page 127 of the judgment. This is a summary of how the defendants in that case and my learned friend had put the argument. And at the top of the page, this begins on the previous page, so it's the final sentence of page 129. It says, Mr. Byington had knowingly and intentionally passed all his demands through Mr. Costa. He had set up a system of ostensible authority. And then at the top of the next page, it says, that being so, the instructions which Mr. Costa gave the respondents were as a matter of law. The instructions to Mr. Byington, whether or not he approved of them, or would have approved of them if he had known, and if that is correct, then the question simply becomes whether Mr. Byington's instruction to the second defendant director to execute the fifth power of attorney, as it then would be, was to be taken as an act of the company. So pausing there, the argument being made is not that Mr. Costa's act had the effect of constituting an instruction which the company directors were then required to put into effect, provided that they were satisfied that it complied with their duties, etc., which is how the respondent frames the position in this instance. It's whether the act, the issuance of that instruction, became an act of the company. And the legal basis for that is very much the same as the legal basis presented in this case. So if you look at the paragraph beginning just above D, it's talking about how multinational gas, so that's the framing of Geomatic, which we've already looked at, was simply an application of the general law of agency to the specific question of attribution. So that's relying on the Meridian case, which we've already looked at. And if we then jump forward, in this case, it's to page 141.
Of the bundle?
Yeah, so tab 9, 141.
9 days. Yeah. Yeah.
From letter D in this page, so it's paragraph 36. This is where we see that the court accepts the application of those principles. So it's referring to, there is also a helpful reference to where the Geomatic principle fits within the general rules on attribution in respect of a company in Lord Hoffman's well-known analysis, giving the advice of the Privy Council in Meridian Global Funds. And then he repeats the points we've already looked at. So that's the company's primary rules of attribution are generally found in its constitution, but there are also those primary rules of attribution which are found in law, namely that the unanimous decision of the shareholders in a solvent company about anything which the company under its memorandum has the power to do shall be the decision of the company. And then at 37, he goes on to say, applying the Geomatic principle to our case, Spectacular would have been bound had the shareholder, Mr. Byington, consented to Mr. Costa's having the authority to give instructions. So bringing that together, the point is relied on.
But in our case, I go back to this question of whether Abdullah was properly given that authority, legally given the authority. You say yes.
Yes, certainly, and I'm just about to come there. I'll round off on this point, just so it's clear on our position. But the point relied on by the appellant is not that unanimous shareholder consent gives the shareholder a basis upon which to then require the directors of the company to act. The point is that the assent of the shareholders is a company act. And we say that that's supported not only in the judgments that we've looked at, but also in the authoritative texts on this issue. And so in addition to those cases that we've cited, I think it would be helpful to round off this point by looking at the extract from Bousted and Reynolds, which is tab 11, page 2. Which is something that was cited by Justice Giles in his judgment and concerns the attribution of acts and states of mind to companies.
Yes. All right.
So on 11 page 2, if you look at the bottom of that page, you'll see a heading agency law and companies. And then there's a section beginning attributing acts, omissions and states of mind to companies. And then the relevant bit starts over the page on page 3. It's a paragraph beginning in the middle of the page referencing Meridian, which says, in Meridian, Lord Hoffman drew a distinction between the primary rules for attributing acts of humans to a company, such as the rule that decisions of the board bind the company, and the general rules for attributing conduct to another that apply to both corporations and individuals, namely the principles of the law of agency. However, Lord Hoffman did not go so far as to state that the bodies of persons who engage the primary rules are not agents, and Lord Diplock's dictum above, together with the weight of authority, clearly takes the view that they are. The primary rules of attribution are best seen, as suggested, as simple sources of actual authority vested in the board of directors, but sometimes in shareholders. The point was put the following way by Lord Diplock in Freeman and Lockyer. It says that such actual authority may be conferred by the constitution of the corporation itself, as for example in the case of a company upon its board of directors. And it then explains on this basis, the board of directors, when acting to bind the company, or to authorize others to bind the company, operate as a body of co-agents. It then importantly says, equally, to the extent that some of the functions of shareholders in a general meeting, or in giving informal unanimous assent involving participating in decision-making on the company's behalf, with a view to alteration of the company's legal position, they act as co-agents. Their authority is the... Oh, it goes on to talk about the source of directors' authority. But stressing those couple of points, whilst what Boston and Reynolds says is that usually the primary rules of attribution are where sources of actual authority to bind the company exist, such as action by the board of directors, and that in that instance, the directors should be seen legally to be acting as co-agents. But the point is that precisely the same legal analysis applies to shareholders acting for the company in those exceptional circumstances where they act unanimously. And what Bousted says is that when shareholders give informal unanimous assent, they participate in the company's decision-making on the company's behalf and with a view to altering its legal position. And they do so as co-agents. And if we go forward to the following paragraph, so this is at the bottom of page 3. It just adds that normally directors and shareholders, making no distinction, will have actual authority as opposed to apparent authority, only when they make their decisions in accordance with the procedures established by the statute and constitution. However, both in relation to directors and shareholders, the courts recognised early on that these groups could also bind their company informally, again making no distinction, so long as it could be established that all the directors or all the shareholders, as the case may be, unanimously assented to the decision, and again it says being made on the company's behalf. In respect of shareholders, Lord Hoffman, the Meridian case, approved the formulation of the concept of informal unanimous assent as follows. And what it actually then refers to is the decision in multinational gas that we've referred to a couple of times already. So the important point is that Geomatic is shareholders making the decision as a Companies Act and on the company's behalf. Bringing our submissions and attribution to a close, we say that the proposition, as it's framed in multinational gas and as repeated in Meridian and as repeated in Bousted and Reynolds, is correct. Shareholders or corporators, whatever you want to call them, in a solvent company can do anything the company can do under its memorandum, and that is a decision directly attributable to the company without more, i.e. without the subsequent resolution or agreement of the directors. There's no suggestion, as I understand it, that the company didn't have the power to deal with London properties in the way that in fact happened. It's just that the respondent says that the mechanism needed to be different, with which we disagree.
In conclusion, you're saying that the decision Abdullah is attributable to the companies,
yes,
to the shareholders, or to the company. There's a company, there's the shareholders, to attribute to the company of the shareholders or the company itself?
It's a decision of the company. It's an act of the company itself. And the reason it's an act of the company is because it's a unanimous agreement of the shareholders. And the reason it's a unanimous agreement of the shareholders is because Abdullah was authorized to stand in their shoes. On the point about what the company's memorandum authorizes the company to do, we reject the notion that this was somehow an ultra vires act because of the mechanism through which it was carried out. It wasn't. The management of the company's property is clearly something which the company was permitted to do. The question is simply, as I say, that mechanism. Is it permissible for the shareholders acting unanimously to manage the company's affairs in that way? And we say that Geomatic entitled Majid and Mohammed to enter into those tenancy agreements on behalf of the company. And in doing so, the BVI companies were directly bound by that. The only thing that
Geomatic, which is a rule of attribution, if you like, that overcomes the limits of which might otherwise be imposed by formalities or stated limits on powers in a memorandum article, that contemplation of the Geomatic principle can somehow be imported into, this will come to the construction of the power of attorney in due course, into the power of attorney. In other words, the shareholders were authorising, that Majid and Mohammed, in a general power of attorney, were authorising Abdullah to do things which could only be attributed to the company with the assistance of the Geomatic principle.
Yes. Yes. So in order for the analysis on what we're not saying is the company provided, say, a power of attorney or like express authority to Abdullah to act as the company's officer in entering into the agreements.
I'm asking you're saying the shareholders, Majid and Mohammed, in a general power of attorney, which just refers to them in any of their capacities, are authorising Abdullah to do, among other things, acts which are attributable by the company, absent compliance with formalities or the terms of the articles, simply because they have authorised him. And there's this agreement. There's a kind of bootstrap thing about this, isn't there?
So the chain of analysis effectively is a linear one, which is to say that the company can act and will be bound by unanimous act of its shareholders. So that's the next part of the linear progression. So that's what we say. That's where we say the line of authorities we've referred to up to this point get us. So the counterfactual, if we got to that point, would be, let's say, Mohammed and Majid themselves signed the tenancy agreement rather than Abdullah.
What is the act of the shareholders?
The act of the shareholders is assenting to, agreeing to the company entering into the tenancy agreement.
Now, that act only exists as an attributed act because of Abdullah exercising that or entering into that agreement purportedly pursuant to the power of attorney.
Yes, so that's the next stage of the progression. So if the court concludes that Majid and Mohammed could have done this as shareholders, the next bit up the chain is to follow the principles in Siban, which says that, well, if the shareholders can do it, they can also confer their powers onto an agent to do the same thing. So effectively, Abdullah steps into the position of both of the shareholders such that his decision or his assent is the shareholders' assent or is taken to be that. And that's the submissions I'll now come on to on Siban and what we say that's authority for.
Well, what about these two companies? If I understand correctly, the arrangement is there's that company that holds the property, and then there are two companies. One is BVI, and one is another company. Am I right there?
No.
And then the individual shareholders below that. Is that am I right? Am I right there, or have I missed some? the
No, so-
arrangement of the setup.
In effect, what we're dealing with is the same point of principle, but it's an agreement entered into by 3 BVI companies.
Yes.
And the mechanism for that agreement being given effect
Is
is
the
that
power attorney.
is through the power held by the shareholders to direct that act and to make it binding as an act of the company. So that's an application of Geomatic and the rules of attribution. And then the third limb, which I'm going to come to just now, is the extension of that principle where shareholders have appointed an agent to stand for them in their capacity as shareholders or as ultimate beneficial owners, as I think was the more accurate description in CBAN. So unless there are any questions at that juncture, that does bring me on to the third building block, which is how agency then fits into this equation. And as a matter of law, I think, at least from the appellant's perspective, I hope we can deal with that in relatively short order, which is to say that in the appellant's submission, it's settled law following CBAN that the assent of a shareholder can be derived from the fact that the shareholder, or in this case, both shareholders, had expressly authorized an agent to act in that capacity. And in fact, CBAN went further than that, holding that an agent can stand in the shoes of a shareholder, in that case, to direct acts of the company, even in circumstances where the shareholder had not assented to that course of conduct, and certainly would not have assented to that course of conduct had they known about it. Because in that case, of course, the agent was defrauding the shareholder. But in that case, the assent was rescued by the agent being cloaked in ostensible authority. Coming back to where we had left off in CBAN, I think it's page bundle tab 9, page 141.
Bundle
9,
9.
Page 141.
Page 141. 141. Okay.
And we had just left off in paragraph 37, which was the court referring to Lord Hoffman's framing of the rules of attribution and saying that applying Geomatic to our case spectacular would have been bound had the sole shareholder, Mr. Byington, consented to Mr. Costa's having authority to give instructions. And then the next bit goes on to start dealing with the question of agency. It says that informal giving of consent by Mr. Byington explains how, and this was not in dispute, Mr. Costa had actual authority to give instructions to TCCL, so that's the director, in relation to the first 4 powers of attorney that it issued. But in respect of the 5th power of attorney, Mr. Byington clearly did not consent by giving Mr. Costa actual authority. The question therefore becomes whether one can apply the Geomatic principle of informal unanimous shareholder consent to ostensible authority. As a matter of principle, there seems no reason why not. If actual authority can be conferred informally by unanimous shareholder consent, the same should apply to ostensible authority. So here, Mr. Byington's informal consent to the representation by conduct that Mr. Costa had authority to instruct TCCL in relation to the 5th POA binds spectacular.
You weren't relying on ostensible authority in this case.
No, we weren't. So we don't even need to go that far. The important point arising is whichever way one frames the argument on how authority has been conferred. The important point is that authority by the shareholder can be conferred on an agent. So in this case, the authority was giving Mr. Costa the power, as though he were the shareholder, to issue instructions to the director of the company. In this case, we say that the power that is donated by the grant of authority is actually an extremely broad power that enabled Abdullah to act as though he were the shareholders themselves. And it probably would assist at this juncture to go to the power of attorney itself. So it's in the bundle, tab 2, page 14.
So Abdullah is everybody. He's the shareholder, he's the director, he's the agent.
No,
No?
he's not the director and he's not the shareholder, but he
No,
carries
but the power, by virtue of the power, he
Yeah.
has all the
Yeah.
powers of the shareholders and the directors.
Well, we don't say that he's the director. We say that
No,
he
he's
has the power
not.
of the shareholders.
He has the powers of the shareholders. Okay.
Chair of the director.
So where is your power attorney?
Cancelliere, un altro avvocato mio.
So I think I can hear. I think it's Mr. Fedrigoli.
E fa un bel lavoro, eh?
I don't know if no, he's on mute
Yes,
now. Okay.
It's Spanish.
The power of attorney, there are two translations. I don't think they make any difference, and the judge certainly didn't. But if you look at tab 2, page 14.
Tab 2, page 14. Okay. Yes.
So we can see it says, let it be known that we, the undersigned, Majid Abdullah Jamal Sari and Mohammed Abdullah Jamal Sari, and then it says, in our personal capacity and in any capacity whatsoever, have appointed Mr. Abdullah Al-Sari. And then we get into the detail of that. So it says, to represent us and take our place with absolute power to transact by way of sale, purchase, and acceptance of purchase. And then for present purposes, it says all movable and immovable assets, obviously broad, but it's also more specific than that. It says real estate properties and lands of various types, vehicles, not relevant, but it then says all properties registered in our names and all institutions of various types belonging to us in our capacity as owners or partners thereof.
What does that mean, institutions?
Well, I think we would say that is, if you look at the reference to owners and partners, it's clearly a reference to companies, or companies, or more broadly, it could be partnerships. So it's meant to be a term which certainly captures companies, but in all likelihood is broader than that. So if there was limited liability partnership or something to that effect, it would also be caught by that umbrella.
Everything else is things in which they have proprietary interests.
It is. It's. I suppose it has a number of effects, because we can see at the beginning where the donation is. It says in our personal capacity and in any capacity whatsoever.
That might be a trustee.
Yeah. I mean,
if I may say something, this is Jajad. If I may say something, I mean, in terms to these institutions, meaning I just looked at the Arabic translation of them. This is power of attorney. And I think, yes, it's not just an institution. I think it's much broader than that. It could mean establishments as well. It could mean it could means like something like what are called agencies, could say corporate bodies, could mean many things, because word muassasat.
Muassasat.
Arabic language, yeah, it's muassasat. It's like if you, and this is referred to in the one of the day and the day IFC jurisdictional gateways articles. DIFC establishment is muassasa, and we know that establishment could mean a company registered within the DIFC. So I think it's much broader than this. I do not mean to rely on my own Arabic language in this, but this is something to assess. But this word muassasat, and some point at the DIFC, I said jurisdictional gateway articles, it's referred to as DIFC establishment. You know what I mean? It's the same word used to refer to establishment, word of muassasat. Muassasa could be a company, could be any corporate body registered within the DIFC. So that's what it means.
I think that's
and then it followed by belong to us. Yes, it's like, yeah.
I think it's a defined term in the Judicial Authority Act, isn't it? Or the Courts Act. The term DIFC establishment. Yeah.
Yes, yeah, establishment. Yes, that's the one. Yeah. Anyway, yeah.
Yes.
Go on. Yes.
Thank you, Your Excellency. That's really helpful. I think I think the point that is captured by that is that Abdullah is being granted the authority to act for Majid and Mohammed in whatever capacity they have in relation to institutions that they own or are partners thereof. And institutions in that context, we say, includes companies, but is probably broader than that. But for today's purposes, we say that it includes companies. And what the terms of that POA enable Abdullah to do is to stand in the shoes of Mohammed and Majid as if he were acting as the shareholder or whatever percentage of their shareholdings they had in respect of any given company. So whether that would be more conventional business of turning up and voting at a general meeting, that would be included. But for present purposes, it also includes acting in concert on their behalf or providing unanimous assent on their behalf to some particular action. And that really is the most important point of the power of attorney. It was an issue that has been raised. As I say, I think it's probably a bit of a red herring because, as you'll probably have gathered from the way we term this, the issue in this case isn't whether the shareholders provided authority or provided their assent to Abdullah being authorized to sign and thereby execute the tenancy agreements. That's not how we frame this case. What we say is that he has the power to do anything that Majid and Mohammed would otherwise have done. And that's why we say that the important counterfactual in this case to consider would be what the legal analysis would be if instead of Abdullah's signature, we found instead Mohammed and Majid's signatures. But perhaps before I move on from this document itself, if one looks at, it's towards the bottom of this power of attorney. It's 1, 2, 3, 4, 8 lines up from the same paragraph, from the end of the same paragraph we've been looking at. We see that there's also a power giving Abdullah the right to sign all documents without referring to us. And again, as I say, we don't necessarily rely on that provision because this case on our analysis isn't about the signing. But in any event, the power of attorney does provide that Abdullah can sign all documents without referring to Mohammed and Majid. And again, as though he was standing in their stead. So based on that analysis and based on Siban, we say we don't even need to go so far as the outer bounds of what Siban decided. Here we say there is the direct conferring of authority by Mohammed and Majid for Abdullah to act on their behalf as shareholders in respect of any companies which they owned or were shareholders of. And so if it happens to be the case that Mohammed and Majid jointly own a company, as in this case, and Abdullah makes the decision or he assents to something, that is the assent given unanimously by the shareholders to that act. And following the line of analysis already set out, that becomes a binding act of the company.
It's curious that given the specificity of various elements of that authority, there is no express reference to exercising their powers as shareholders.
Well, I think that again, it's a product of the power being drafted in even broader terms, because it's not talking specifically about companies; it's talking about institutions, i.e., the broader umbrella term. It then is speaking of them as being owners or partners thereof, and we would say that when you take that language, what it means is, in whatever capacity they have a right in the company. So in this case, it would be shareholders. In a partnership, it might be that they're partners. It might be that where they are the sole beneficial owner they're just simply the owner. It's broad enough, we would say, in addition to that, to cover, for example, the ultimate beneficial owner scenario, which was discussed in CBAN. So what they said in CBAN was, in addition to that there was no particular requirement that we be dealing with the position of the shareholder, and that the principle of agency that was applied in that case would apply equally, whether it was a shareholder or whether it was an ultimate beneficial owner. So maybe that's owning a shareholding beneficially through a chain of companies. The point is that the authority can be donated either way. So the fact that the POA doesn't refer expressly to shareholders, I don't think has any particular bearing on the outcome of this case. So very, very brief roundup. The 3 building blocks, so I refer to them. 1, Salomon and Geomatic tell us that a company is bound by the unanimous act of its shareholders, whether it's made formally or informally. The point of the rule is to avoid becoming entrenched in formal requirements. So that's building block number 1. 2, the principles derived from express engineering, applied in Geomatic, and Meridian, applied in multinational gas and CBAN, says that the acts of those shareholders are then acts which are directly attributable to the company without more. Building block number 3 says that whatever power the shareholder or the ultimate beneficial owner has can be donated via either express power of attorney or through express authority, or indeed through the provision of ostensible authority. And that's the 3rd building block, which takes us to the point where Abdullah can provide that assent on behalf of the shareholders, which then becomes the binding act of the company. So that's, we say, how the correct legal analysis in this case works. That's where the principles get us. The next matter, I think, which I can address your lordships relatively briefly on, is to go back to the grounds of appeal and to the parts of the judgment that the appellant disagrees with. So the first ground is that we say that Justice Giles respectively erred in law in misdirecting himself on the appellant's submissions on the authority issue in the Geomatic principle, and so failed to adequately address the central issue which was before the court, which is what were the shareholders empowered to do, and by extension, what was Abdullah empowered to do. If we look at Justice Giles' decision, it's in tab 1, and the first page I'll refer you to is page 31 of tab 1, that is. It's paragraph 39 of the judgment. So 39 is the beginning of the analysis on the legal principles. So very, very briefly, we can see 39 hits on some of the points we've looked at. So it's referring to Salomon, Geomatic, and Mr. Justice Buckley's judgment in that case. Paragraph 40 is referring to another summary of the Geomatic principle in a case called EIC Services and FIPS. And one of the issues considered in that case, although I don't think it has any particular bearing on this case, is about timing and how assent might be seen to be provided, and whether it can come before or during, after the act. Paragraph 41 then cites, without purporting to disapprove of any of it, the principles summarised in Bousted and Reynolds, which include the Meridian analysis that I've referred you to. And then really it's from paragraph 42, where we say some of the issues with the judgment arise.
The crunch point is 49, is it?
The crunch point eventually is 49. I think some of the prior reasoning builds into how we get to the to the mistake that we say exists in paragraph 49. So in 42, the judge suggests that the appellant had relied on SIBAN to say that the Geomatic principle applied in order to enable unanimous shareholder assent to authorise an individual to act for a company by the conferral of authority, and that the act to which the shareholders applied their consent in this issue was authorising Abdullah to enter the tenancy agreement. So the relevant act of the shareholders in the judge's analysis, and therefore an act of the company, was the conferral of authority on Abdullah, specifically with respect to the tenancy agreement. We say that's actually much more narrow than the way that the appellant has framed its case. What we say is that Majid and Mohammed conferred a broad authority on Abdullah to act for them in any capacity, including in relation to the companies they were partners or shareholders of. So it's not simply the case of shareholders authorising Abdullah to do a specific thing or to enter into a particular agreement, or for that matter, to execute a particular agreement. What's conferred on him is the power to do anything which they as shareholders could have done. If we go on to paragraph 3, we see the same error of reasoning arising. So paragraph 43, Justice Charles describes there being a question as to whether there was assent of Mohammed and Majid to the defendants entering into the tenancy agreement. Again, we say that wasn't the question. The question is whether there was the assent of Mohammed and Majid to a third party, i.e. Abdullah, exercising the entirety of their powers. At paragraph 44, we then have the judge posing the wrong question in the case as being not simply about a decision to enter into the tenancy agreement, but whether Abdullah was authorised to enter into the tenancy agreement on behalf of the defendants by his signatures. Again, we say that isn't correct. We're not saying that the shareholders assented to Abdullah signing on behalf of the company, thereby giving him that authority to sign. It's simpler than that. It's he could do whatever the shareholders could do, including but not limited to entering into the tenancy agreement. At paragraph 45, we then get to one of the critical errors in the decision making. What the judge says there is that execution of an instrument is not a matter for shareholders in a general meeting. And I think that's a point that is repeated in paragraph 49. And we say that misses the point because following Meridian and express engineering, those principles of attribution combined with the laws of agency mean that Abdullah's act of entering into the tenancy agreement was an act of the company. So it doesn't need to be formally ratified by the directors. The company is already bound by it at the point at which he signs, which is, I suppose, on this analysis, evidence of the assent having been provided. It doesn't need to be executed. That's just evidence of the act happening. The formalities rules, we say, are irrelevant, and the whole purpose of the geomatic principle is to try and avoid that formalistic approach altogether. And so we say that the judge was wrong. The proper way of analysing this case is to say that the shareholder could directly bind the company by entering into the tenancy agreement. As I say, if we find the signatures of Mohammed and Majid, that's what the outcome would have been. From Siban, the same conclusion is reached when Abdullah signs the agreement because he is authorised to stand in the place of the shareholders. And following the authorities we've referred to, at that point in time, this is a binding decision of the company. It isn't necessary for the formalities of the constitutional documents to then be followed to give effect to it. It is already effective and it is already binding. And so we say that on that basis, that aspect of the judgment is wrong and shouldn't have been entered into. On ground 2, we go further in saying that there were further errors in the judge's application of that statement of principle to the facts of this case. And it's an interrelated point, but it comes to paragraphs 49 and 50 that you referred to. So at paragraph 49, the material part is the final couple of sentences, which Justice Giles says, but the claimant's argument fails for a more fundamental reason, let it be assumed that Majid and Mohammed informally resolved that the defendants should enter into the tenancy agreement apart from the power of attorney, and in the absence of evidence from any of Mohammed, Majid and Abdullah, there is nothing to warrant finding that they informally resolved that it should be signed by Abdullah on behalf of the defendants. The power of attorney is the essential link to that appointment of Abdullah, but it's a false link. It empowers Abdullah to act on behalf of Mohammed and Majid, not on behalf of the defendants. Put another way, in the claimant's reliance on the power of attorney as embodying Abdullah's authority, he signed the tenancy agreement not on behalf of the defendants, but on behalf of Mohammed and Majid. To say that he signed on behalf of Mohammed and Majid as their capacity as beneficial shareholders does not work, because signing is not something for them in a general meeting of defendants. That's what's said to be the fatal flaw on the legal point. And we say that that's a misapplication to the facts presented and in the context of this case, because the issue isn't that execution issue. It's not whether the shareholders unanimously agreed that Abdullah could sign the tenancy agreement. That's an unduly narrow framing of the question, which we say is over concerned with formality. But instead, it's whether Abdullah's signature can be taken to represent the unanimous assent of the shareholders, such that by that act, it is a binding act of the company. So it's not whether shareholders sign and thereby execute an agreement, it's whether that is evidence of shareholder assent, such that it is an immediate and binding act on the company. And so the power of attorney...
Okay, in your submission, what is the relationship of the shareholder? What is the relationship of Abdullah to the shareholders?
As a matter of fact, he's their father. In this case, it wouldn't matter if it was Abdullah or any other third party.
No. I'm talking legally. What is the legal relationship? Not the family relation. I'm talking about this in the context of what we are arguing now. Abdullah. Yes, go on.
Abdullah is an agent who.
Agent. No, you say Abdullah is the agent.
Who's cloaked with the express actual authority to do anything which Majid or Mohammed could have done as shareholders.
Abdullah you're saying is the agent of the shareholders?
Yes.
That's where the judge at first instance disagree with you, isn't it? In paragraph 49, he said, put another way, the claimant's reliance on the power of attorney as embodying Abdullah's authority. He signed the tenancy not on behalf of the defendants, but on behalf of Mohammed and Majid.
Yes, so I don't think that the judge's reasoning rejected the notion that Abdullah could have acted as agent for the shareholders. I think the point at which the judgment is wrong is that the judge approached the question of authority and assent by reference to the narrow question of whether Abdullah carried the authority to execute the tenancy agreement on behalf of the company. And what one would normally expect, if that is what was intended, would be that the directors would have issued a power of attorney on the part of the company permitting Abdullah to sign. But that's not the way that the appellant frames its case. The way the appellant frames its case is to say that the power of attorney gives Abdullah the power to do anything which the shareholders could do. And as a matter of law, the shareholders, acting unanimously, were able to, by their unanimous assent or agreement, enter into the tenancy agreement and to undertake acts which are directly binding on the company. So that's the primary, one of the two primary rules of attribution.
Who are the shareholders? The shareholder is not Jah Abdullah and
No,
Muhammad.
Mohammed, it's Mohammed and Majid are the shareholders. They hold 50% shareholding in the BVI companies.
60%. Yeah, because they are infant.
50% each. So they own 100% of the shareholding.
But where is this where the children are also involved? Oh, there is the tenant. The tenants are the children also involved. And yes.
There are other tenants, but the IGPL, the appellant, is it's the case. I think the trial judge accepted that he could deal with the application made by the respondents in relation to IGPL, despite the fact that there are other tenants who are minors. I think children of Majid and Mohammed. Is that right, Mr. Doe?
Yeah, minors.
Yes, they were all minors at the point in time the agreement was entered into, but that's no longer the case. But some are still minors.
They call the other tenants with a big O, I think.
Yeah, but the point is that Mohammed and Majid together own the 100% shareholding of the BVI companies, who are disposing of a beneficial interest in their property by entering into the tenancy agreements. And we say that the company is bound in that step because Majid and Mohammed, as the 100% shareholders, assented to it. And the reason we know they assented to it is because Abdullah assented to it and because of the power of attorney.
Okay.
That's exactly right.
So by virtue of the power of attorney, there are shareholders, and following Geomatic and the others, they are deemed to have, and Geomatic, the judge says that doesn't matter in business, if they are supposed to be acting as shareholders, then we have to assume you're acting as shareholders or directors. So in this case, yeah.
There are two.
Yeah, so your suggestion is Majid and Majid and Muhammad and Majid and Abdullah was acting in their capacities as shareholders when they gave their power attorney, or they had in back of their mind that they were also acting as shareholders.
They donated a power of attorney which permitted Abdullah to act for them in their capacities as shareholders.
Yes.
Then the next level of the analysis is that as 100% shareholders,
yes,
the law says that when you look at these primary rules of attribution, a company can be deemed to have acted in a number of ways, including if the directors have acted in accordance with the articles. But the other way that they can act is through the unanimous agreement of their shareholders. So this case wouldn't be before the court today, for example, if Majid and Mohammed owned a 99% shareholding in the company, but there was another minority shareholder. In that case, unless there was a specific provision in the company's articles, the respondent would probably be perfectly right to say that the only way that this can be carried is in a general meeting in accordance with the Articles of Association, or by the directors acting in the normal way for the company. But this is a special rule that applies where unanimous agreement exists.
Okay, does the two grantors of the power attorney, the donors of the power attorney, do they have other properties as well?
I would imagine so, but none that are necessarily in dispute in these proceedings.
No, the reason is if they don't have any other properties, then when they say we are owners of the property, it must mean this breach property. It cannot be any other property. But if they have other properties, then that power attorney could be referring to other properties, but not this particular one. Because if they say they are owners, they're owners. Whether beneficiary, legal owner, but they're owners. That's what your contention is.
No, we don't assert that the shareholders are owners of the physical property. We know that they're shareholders. It's as I said at the outset, it's a question about the powers of shareholders, not about the proprietary rights of shareholders. Their proprietary rights are to the shares that they own.
Yes.
And
Yes.
they can dispose of their shares, for
Yes.
example.
Yes. Yes.
And it's a long-established principle that they
But
can.
ultimately, they own the property. You know, whether through shares, through company, whatever it is, belongs to them, and they can do anything they like, whether via a company or on their own or.
Ultimately, that may well be the practical effect, and that indeed is, I suppose, what we do say the practical effect is, because, you know, let's assume you've got one owner and you own property through a chain of companies. What we would say is the effect of Geomatic is that you, as the sole shareholder, can direct and bind the company in respect to the company's property. It doesn't mean that legally you own the property or that you have a legal interest in it or a beneficial interest in it, but you own it through some form of chain. But the important point is that if you do own the 100% shareholding, you can direct the acts of the company. That's really
The way I
the
understand it, that must be your contention, because you are saying that Muhammad and Majid can give the power attorney to Abdullah, and they can, as owners, you know, as shareholders, whatever it is.
Yeah.
It must be that way. It must be read that way. You can, in no other way can it be read to say that they have given the power attorney to Abdullah to act on their behalf.
Yeah, that is our position.
The judge in a particular, paragraph 49 seems to be reading it very strictly, distinguishing between a signing on behalf of the companies and signing on their own personal behalf. That is 49. The judge drew a distinction to that. But you are saying that it doesn't make a difference, because under the power attorney, they have all these powers because they're owners.
Ultimately, right? Yes. It's a slightly different point that we make, which is to say the signing, the execution isn't the thing that means it's an act of the company. It's to say that the shareholders can, by their unanimous agreement, lead to the company acting in a way that disposes of the company's interest or partial interest in the property by granting the tenancy agreement. So yes, ultimately the practical effect is the same, albeit that there's a chain of legal analysis in it.
Is there anything else you want to say, Mr. Doti?
Let me just check my note whether there's anything else at this stage. I think I've covered what we say. I should probably highlight our. You led on nicely to what our ground 3 was, which was the judge erred in construing the proper scope and effect of the power of attorney. I don't think I need to repeat the submissions I've already made on that. We say that it's much broader and that the issue before the judge was also much broader than that. So those are my submissions, unless I can be of further assistance at this juncture.
Okay, thank you very much. Okay, this action was filed by the respondent in this case, isn't it? They were seeking for specific injunction. Was it?
I'm happy to pick that up. So the origin of the case was because of steps being taken to sell the London properties. Igpl, the appellant, applied ex parte for an injunction, which it got, and then the application made by the respondents was an application for immediate judgment on the issues that are now before the Court of Appeal. So the issues today arise from the respondent's application being granted.
Assuming we are inclined or we decide in your favor, what happens? What are the sort of orders that you will be seeking for? What was it? Can you?
So we're asking for the order for judgment to be set aside, and that if we are successful on this appeal, it follows that the legal principles are in our favor, and that the judge had decided that some of the residual factual issues surrounding the provision of assent were not capable of being dealt with by way of immediate judgment, so that would have to proceed to trial. So what we say is that the immediate judgment order is set aside and then the matter proceeds to trial.
Okay. Yeah, that's what I want to know. But why he proceed to style all the issues of fraud, allegation, whether it's a sham agreement, with all that will be regurgitated, will be argued at trial?
Yeah, so the judge had already decided that he wasn't able to deal with the sort of separate set of issues relating to sham at a summary disposal stage. So what would proceed to trial then is all of those sham issues.
The factual issues will be tried. Will be decided at trial. Factual. We are just deciding the law now on the assumption of the facts as we had argued, right?
Yes. Yeah, so it's a question of whether the appellant's case stands up in law sufficient that it can then proceed to trial.
The question is, I suppose, Mr. Doherty, whether the judge was right to hold that you had no reasonable prospects of success on this question. And you've raised in your additional ground, which has been put off to another day, the question of potential additional evidence that might be given, which presumably might come from Majid and Mohammed and Abdullah and so forth. Would a finding in your favour need to go further than that the judge was wrong to hold that there was no reasonable prospect of success and leave open the question of ultimate authority because it might involve factual issues? Or are you saying that the question is really determined as a matter of law by this appeal? The question of authority, as it were.
Yes, bear with me. I think I can find an easy answer to this question in the judgment. I'm just trying to remind myself where it was. But effectively, I think there are still residual factual issues that can have a bearing on the outcome of this authority assent question. So the decision today wouldn't completely dispose of it, but it would say whether it stands up in law effectively.
It'd be an overlap, potentially a factual overlap with sham arguments, wouldn't there?
Potentially. I think the factual premise might be the same. I think the legal arguments that would apply would be quite different. But yes, I think that is right.
Yeah.
And I think that that's something that the judge acknowledged in his judgment. Bear with me. I think it's at paragraph 40 something. Yeah, so paragraph 49, we see the reference to that aspect of it. So it's the defendant's submissions included that the assent of Mohammed and Majid to such an appointment of Abdullah could not be found because it was demonstrably not known by them that Abdullah was signing the tenancy agreement. The basis for that being that the tenancy agreement had not been disclosed by them in some affidavits provided in 2014. And what the judge says is, I do not think that is a finding which can be made in this application.
Yeah.
So
then I suppose, I mean, I don't know whether it's been raised, but I suppose there might be questions about the construction of the power of authority, which might invoke context and surrounding circumstances. Or is
it
that
could be. I don't know that any of those have necessarily been raised.
Yeah.
But I think that the important sort of question of principle is, can shareholders act in the way that the appellant says? And if they can, then the matter is held off to trial to deal with the sort of factual issues and the broader submissions on that. And we would say that when one frames the appellant's case properly through the broader way we put it, rather than through the narrower framework that we say was adopted by the judge, that clearly this is a case that would have got over the hurdle on an immediate judgment application. Indeed, is the fact that we've been given permission to appeal implicitly acknowledges in some respects. And so for that reason, we say that whatever the residual issues are, need to proceed to trial.
Yeah.
Okay, presently the property is in the hands of the receivers, right?
I think
the shares are presently in the hands of the receivers.
Yes, the shares in the hands of the receivers, the property is, for the most part, in the hands of the companies. There are parts of the property that have been disposed of and sold to third parties. But to all intents and purposes, the BVI companies own the London properties. The receiver controls the shareholding.
Is there any injunction holding freezing order holding the receiver not to dispose the property at this while this case is going on?
The injunction the injunction that's currently in place prevents the sale of the properties. Okay. So by extension, one would say that the receiver's hands are tied not to take steps to sell those properties.
And the injunction is obtained, I assume, enforced by the English courts because the property is in England.
We have an injunction. We have the ex parte injunction granted by Justice Giles in this case.
Well, freezing order. Okay, then if there's nothing, then we'll hear Mr. Thompson.
I'm grateful, my lord. Just to address the very last point the Chief Justice asked, the receivers, as I understand it, have sold their shares in the 3 defendant companies to an SPV, but nothing turns on that. It's simply the case that it's no longer held by the receivers themselves. It's held by
to the bank's SPV, isn't it? Okay, yeah,
exactly so. Exactly so. In light of the most recent discussion, I wonder if it would just help if I identify from the respondent's perspective those facts which are accepted for the purposes of this application and this appeal. As your lordships discussing with my own friend have identified, there may well be a much wider range of factual questions that fall to be determined at trial. But for the purposes of today, and indeed for the purposes of the application before Justice Giles, there are certain concessions made by the respondent which make the matter, I hope, somewhat easier. Firstly, although Mohammed and Majid are only the beneficial, or were only the beneficial owners of these BVI companies, it is conceded, at least for the purposes of today, that they had exactly the same powers and duties as the shareholders. They weren't actually the registered shareholders. It's also accepted that between them, they were in effect the entirety of the body of shareholders of the defendants. So they were, as Mr. Doty says, 100% of the shareholders of the companies. That's a premise on which we're all prepared to proceed today. I'm also prepared to proceed today, though this is likely to be a much contested issue later, on the basis that Abdullah, their father, was duly authorised by the power of attorney, which your lordships have already had a look at, and that power of attorney enabled Abdullah to deal with Mohammed and Majid's interests in property, including their interests in the shares, as he thought fit in quite wide terms. Again, just on the facts, can I show you, just to put this point into context, the underlying tenancy agreement which we're here concerned with at tab 2, page 1. You didn't look at this, but I just want to show you this to show the context of the agreement for the purposes of the appeal. This is an English law tenancy agreement, which it is accepted by my learned friends' clients, was not or does not take effect as a lease as a matter of English law. It has all kinds of issues with it. For example, the formalities, the fact that the tenants are a company and minors, it cannot be what it says on the face of it. But on the face of it, it says it's dated the 16th of January 2013. Yes. For the purposes of this appeal alone, we are prepared to accept that it is in fact an agreement made on that date. Yes. At trial, it will be contested, as your lordships know, and we will be saying this was made up after the event to avoid the painful effects of execution, given that Mohammed and Majid have an unpaid judgment against them for hundreds of millions of dirham. The landlords on the face of this agreement are then the three BVI companies for whom I act today: Hortin, Lodge Hill and Westin. They're all BVI companies. They owned different interests in this property in London, freehold and leasehold interests. The tenants are Malone Friends client, Igpl, and a number of minors at the time. You can see the oldest one at the time was, I think, 9, maybe 10. He was born in 2003. The youngest one was 4. So patently, they wouldn't have the capacity to sign or approve a tenancy agreement. You can see the properties on page 2 of tab 2. Now, there are all kinds of terms I needn't take you to, but I will take you to a couple of them. Term 4, which shows that there's a 15-year tenancy, which this agreement is purporting to offer, and it is for a rent of £850,000. That's at 5. We will have much to say at the trial about the commerciality of that, about the rent, about whether it was actually within the power of the company to grant these leases, given the other leases which had already been offered by these landlords. But again, for the purposes of today, we're prepared to accept this is what it says it is. If you turn to page 7, this is the last point on this document I want you to look at, you can see, and this is not contested at all, we can see that it was Abdullah who signed on behalf of all the landlords and all the tenants. That is why there is no possible argument about ostensible authority, because Abdullah couldn't possibly complain in this case, and to be fair, he doesn't complain, that he was confused or led to believe that somebody on the other side had certain authority, because he was on both sides. So that is the background and the facts which are agreed and not agreed. Can I address, before I turn to my the body of my submissions?
Thompson, Sir Thompson, so if you succeed in your argument, then that's the end of the matter, isn't it? We wouldn't go for trial.
Yes.
That's
yes, ma'am. Yes. If you uphold what the first instance judge said, he said, even accepting all of those concessions, even if this agreement is valid, was made on the date it says, and takes effect as an agreement to lease, it actually is ineffectual to give any rights to Igpl. And therefore Igpl cannot bring this action. Now, I'd like to address parenthetically, if I might say, the question which was asked by Justice French right at the beginning of today's hearing, ostensibly to both of us, but which I didn't address. If I wrote it down correctly, the learned judge said that the real question in this case is whether the shareholder had authority to deal with the property of a company rather than any question underlying Geomatic. With 2 provisos, I respectfully agree entirely that that is the central question in this appeal. The 2 provisos of this, I will prefer, and I will try very hard in the course of my submissions, to use the word power rather than authority when talking about what the shareholders could and couldn't do. That's because the question of authority, or the word authority, gets tied up in this case and indeed in others with questions that fall out of whether somebody has authorized another party to do something. We're here talking about whether in fact the power lies at one particular level of the company or not. The other proviso with respect to the judge is that, in my respectful submission, this question can only really be addressed, if it's going to be dealt with, by looking at these cases in considering the third party's rights thus acquired. I'll expand upon this submission, but in summary, let me explain what I mean by that. There are many, many cases, and Mr. Doherty relies on several of them, in which the critical question for the court is what is the relationship between the shareholders, the directors, and the company, often in liquidation. This case before your lordships is not one of those. This case is about a third party, a putative tenant, purported tenant, who claims, by bringing this action, that it has obtained a right as against the company. So this question is foursquare about third parties obtaining rights as against companies, because it's a claim bought by a third party, albeit one controlled by Abdullah, against the company or the companies. So I entirely accept, with respect, what the learned judge said, Judge French, about Geomatic. It isn't a case about Geomatic and the principles decided in Geomatic and the subsequent cases, and I will expand upon that in due course. With that background, I just want to say one overarching comment about Mr. Doherty's submissions, and why it is that in my submission, Mr. Doherty is leading your lordships up the garden path. That is this: Mr. Doherty selects quite carefully dicta from numerous cases that seem on the face of it to support his case. In fact, as I will show, they don't support his case because the dicta are taken out of context, and that is because, as I've said, all those cases are concerned with the rights and obligations between shareholders, directors, and sometimes liquidators of companies, not third parties. I want to just take you to the primary rules about how these particular companies operate, and pause there to just consider how that works and how it would work if Mr. Doherty was right. Can I take you to page 750 of the bundle, which is tab 6, page 586. I apologize, I don't know which versions. 6-586. And I'll tell you what this is. This is the section in the British Virgin Islands Business Companies Act that dictates how it is that BVI companies operate. So section 109 is the one I want your lordships to look at. I cited it in the supplemental skeleton. 109 sub 1, the business and affairs of a company shall be managed by or under the direction or supervision of the directors of the company. 2, the directors of a company have all the powers necessary for managing and for directing and supervising the business and affairs of the company. 3, subsections 1 and 2 are subject to any modifications or limitations in the memorandums or articles. Now that is familiar to any common lawyer, and in fact it's trite company law that the board of the company is the institution which has the power necessary to manage the business and affairs of a company. And it is, as I will show you, the only institution under the statute and the articles. Now, Article 109.3, it says that these subsections are subject to any modifications or limitations in the memorandums or articles of the company. So let's have a look at the relevant article of the company. Again, something my little friend rather skirts around is the article which you'll find at tab 6, page 812. Tab 6, page 812. That's at page 976, I think, of the bundle.
812.
Now, this is in the Articles of Association of the first defendant, so that's Hortin. These haven't changed from its incorporation to now. And under the heading Powers of Directors, it says the business of the company shall be managed by the directors, who may pay all expenses incurred preliminary to and in connection with the formation and registration of the company, and may exercise all powers of the company as are not by the Act or by these regulations required to be exercised by the members, subject to any delegation of such powers as may be authorised by these regulations, and to such requirements as may be prescribed by resolution of the members. But no requirement made by the resolution of the members shall prevail if it be inconsistent with these regulations, nor shall such requirement invalidate any prior act of the directors which would have been valid if such requirements had not been made. Can I just focus a little bit on the first 3 lines of that article? The initial premise from which there are some exceptions is that the business of the company shall be managed by the directors. Now that is replicating, indeed lifting, I think verbatim, the words of the Act at section 109 that I read to your lordships. Now there are then the provisos. It says the directors, this is the second line, may exercise all such powers of the company as are not by this Act or these regulations required to be exercised by the members. So there's a distinction here. If there are powers that under an Act have to be exercised by a member, then the board can't exercise it. The board can only do what the members don't have power to do. And it's also subject to any delegation of such powers as may be authorized.
Hang on. Can you sort of, the business company shall be managed by directors who may be and may exercise whatever as not exercised by members. Shall be exercised by members subject to the and exercise all such powers as are not by this Act required to exercise. Okay, go on.
Yeah. So the effect of this is to delineate the powers which can be exercised by members and the powers that can be exercised by directors. It's trite law that every common law country has included within its Companies Act certain powers that only the shareholders can exercise. So, for example, it is very common to say that it is for the shareholders to appoint the directors or the auditors of a company. Now, there may be, and oftentimes there are, powers where a director can appoint a director to a vacancy, so a board can appoint a director, but only till the general meeting, at which point the members then have to reconsider it. It's up to the company, against the background of the statute, to decide how to break down the powers and allocate them to the shareholders and to the directors. And that's what the articles do. The articles set out.
But this man, Mr. Thompson, this man is both everything. He's the shareholder, he's the director, he's everybody. There's a contention of Mr. Doty.
No, with respect, my lord, he isn't. This man, he is not the director. That's the point. There is a point that I think has been missed in the submissions, is that these companies had a director. It was another company. It was a company called Air. So Abdullah is nothing to do with the directors. The critical point in this case is that Abdullah, even read at his very highest, is acting on behalf of the members. He has nothing to do, with respect, my lord, with the board of directors. The board of directors, and that's why this case has come to this, the board of directors knew nothing at all about this power of attorney, knew nothing at all about what Abdullah was purporting to do, if he did it at all. So, with respect, my lord, Abdullah must be considered only in the camp of the members. He has nothing to do with the directors. That isn't actually in dispute in this case. What Mr. Doty says, it doesn't matter. It doesn't matter that the board of directors didn't know about this because the members could override that. Our primary submission is that that is wrong because it ignores the articles which delineate the powers between the members and the directors. So just pausing there, it's again pretty trite to recognize that in any common law company, the board of directors usually has the power to do things like buy and sell property for the company or lease property of the company. It's trite law that in almost every common law company, the shareholders are given superior rights, such as whether they can appoint the directors or remove the directors, and indeed whether they can issue more shares or authorize more shares to be issued at all. But these ultimately turn on the articles of the company, but the powers are distinct. Now, just thinking about this as a matter of common sense, that obviously is for the benefit of, amongst other people, third parties. Because if a third party is dealing with a company, an a fortiori company in an offshore jurisdiction, the third party needs to have some way of knowing whether the person he's dealing with is in fact empowered to buy or sell or deal on behalf of the company. And so again, it is trite law that the way, or trite practice in fact, that the way in which third parties actually conduct business with offshore companies is to require documentation to show that the person they're actually dealing with, or the individual they're dealing with, is in fact authorized by the board of directors. So they will deal either with a man who is on the face of it a director of the company and the only director of the company, or with a person who is authorized by the board of directors to act on behalf of the company. That is how business functions. Just take Mr. Doherty's position to its conclusion. Mr. Doherty's position is, well, members can do all of that if they act unanimously. If that were the case, I just want to show you how extraordinary his proposition is before I show you that the law doesn't support it. If that were the case, then you might deal with a company on a Monday and take a lease of some property from the board of directors. The board might authorize a lease of some property to you on Monday. On Tuesday, the shareholders might grant a lease to somebody else of the same property. Now, the second tenant, the one who gets his lease from the shareholders on Tuesday, would move into the property and find there's already somebody there. Now, the second tenant would then raise up his arms and say, well, I was dealing with the shareholders who are all authorized because they acted unanimously. They're authorized to bind the company. And yet this property has already been granted. Now, what would the court say if that second shareholder went to court and said the shareholders all acting together must have the power to grant this lease? What would the court have to say? Now, there's no mechanism which Mr. Doherty can point to for the shareholders being informed of acts of the directors, or the directors being informed of the act of shareholders. There's no requirement here for the directors to tell the shareholders every day, well, today we've granted a lease, or for the shareholders to ask the directors, have you granted a lease of this property? So it would make the functioning of the company quite impossible.
I mean,
and that is
from the point of view of a third party, it would be no different from a natural person entering into a lease of a property with person A on one day and an inconsistent lease with person B on the next day. So you're really talking about the practical implications for the internal functioning of the company.
I think it goes a little bit further than that, because in the example of an individual doing it, then on the second day, the individual would be plainly acting fraudulently, because the individual would know that he granted the lease on day one. In the case of a company, the shareholders would be entitled to say, well, we're allowed to do this. This wasn't a fraud. We, the company, as far as we know, had the property. It's just tough luck that the tenant only signed up after the directors had already granted the lease. So the position vis-a-vis the members would be that they would be perfectly entitled, according to Mr. Doherty's argument, to do exactly that, but the tenant would be left completely at sea. So the tenant would receive nothing at all. Now, that could be a position of law, but what it would mean is that any tenant would be extremely unwise to deal with the shareholders, given that it was the directors that had the power. But then take another example. Imagine that shareholders granted the tenancy on Monday and the directors did it on Tuesday. If that happened, again, it would be the second tenant who had his lease from the board who was left without a remedy. And yet he would say, but the directors are the ones empowered. I have the articles, I have the certification that this was the board I was dealing with. Why are the board of directors granting me a lease when the company had already given the lease to somebody else? So it does show that in an example completely without any incidents of fraud, it would make the dealing of a company quite impossible. You couldn't deal honestly with shareholders or directors of a company because you would have no idea what had happened differently. Of course, it bites internally, to answer my Lord French's question, it bites internally because actually what the articles do is make clear when it is the directors may do something and when it is the members may do something. So actually, what Abdullah ought to have done in this case is to look at the articles of association of the company and work out that actually Mohammed and Majid did not have the power to deal with the business or assets of the company, and therefore he didn't either, and therefore he shouldn't have granted a lease to Igpl, who he was also acting for. With that context, with that background, you can then ascertain whether there are any cases that support Mr. Doherty's submission. In my respectful submission, there aren't any. But before we do that, can I just look at the two additional cases which we cited in our supplemental Skeleton argument that show that on this point Mr. Doherty must be wrong. The first one I want to look at is Towcester Racecourse, which is at tab 12, and it starts at page 135. Now, this is a first instance decision in an English court of Mr. Justice Patten, as he then was. Mr. Justice Patten became Lord Justice Patten, of course, and it is a case about the particular power of members as against directors to conduct business. And I only need to take you, I think, to paragraph 18 and 19, and we've cited a large chunk of this case in the supplemental Skeleton argument. But right at the bottom of paragraph 18, the last three words, you can see that the judge says, in Gramophone and Typewriter Limited and Stanley, Buckley LJ, different Buckley, summarised the position in this way. This court decided not long since in Automatic Self-Cleansing Filter, Syndicate and Cunningham that even a resolution of a numerical majority at a general meeting of a company cannot impose its will upon the directors when the articles have confided to them the control of the company's affairs. The directors are not servants to obey directions given by the shareholders as individuals. They are not agents appointed by and bound to serve the shareholders as their principals. They are persons who may be by the regulations be entrusted with the control of the business, and if so entrusted, they can be dispossessed from that control only by the statutory majority, which can alter the articles. So just pausing there, Mr. Doherty might say, well, that's a majority as opposed to the entirety of the members, but you can see from that extract that that isn't the critical point being made by Lord Justice Buckley. The critical point being made is that the directors have the power which they can be dispossessed from by alteration of the articles and, as I'll come to later, potentially by a direct special resolution to stop them doing something. But otherwise, they have that power as a board, as directors, to conduct all the business of the company. John Shaw is the most clear case on this, my respectful submission, which is cited in the next paragraph by Mr. Justice Patten, and John Shaw has this extract. A company is an entity distinct alike from its shareholders and its directors. Some of its powers may, according to the articles, be exercised by directors. Certain other powers may be reserved for the shareholders in general meeting. If the powers of management are vested in the directors, they and they alone can exercise these powers. The only way in which the general body of the shareholders can control the exercise of the powers vested by the articles in the directors is by altering the articles, or if the opportunity arises under the articles, by refusing to re-elect the directors of whose actions they disapprove. They cannot themselves usurp the powers which by the articles are vested in the directors any more than the directors can usurp the powers directed by the articles in the general body of shareholders. And that extract really underscores the point I was making about the delineation of the powers. In paragraph 19, Mr. Justice Patten goes on to say, these decisions were concerned with the extent to which the members of a company could control the actions of the board of directors, where the articles of association vested in the directors the exclusive control of the company, of the business of the company. They recognise and respect the rights of the members to enforce compliance with the articles insofar as the articles of association guarantee specific rights to the members as such. Obvious examples of this are the provisions governing the convening of general meetings and the rights of members to vote on resolutions at such meetings, or the articles, if any, providing for the payment of dividends. But by the same token, and in the absence of articles permitting the members to control the board, it is entitled to govern the company and to exercise its powers without interference. If the directors act unlawfully, then they'll be accountable for their actions and for any losses suffered by the company as a result. But again, the proper claimant in such proceedings is the company and not the shareholders. Limited exceptions are, of course, made to this rule where it can be shown the ability of the company to bring such proceedings is being frustrated by those in control of the company to the unfair prejudice of its members. So really what this 2002 case shows is that the 20th century authority on this particular point is quite clear about the power of a board of directors to conduct the business of the company without interference from the shareholders, because the shareholders' rights are ones that are exercised at a higher level, appointing the directors or removing the directors, and in certain circumstances acting when the directors are unable to act. But otherwise, for pragmatic and legal reasons, it's for the board of directors to conduct the business of the company. Now, with that background in mind, one can turn to the cases that Mr. Doherty relies upon and identify why it is those cases weren't addressing this question, but were addressing a much narrower question about the the position of the directors in the company when the shareholders had already approved something, or sometimes had ratified something the directors had done. Salomon, of course, is the first case in this. My learned friend relied upon the judgment of Lord Davey. More commonly, this case is cited, or the speech of Lord Macnaghten is cited in this case. Can I take you to tab 9 at page, it's 33. 33, yes, actually, can I pick it up at 30? Of course, Salomon, being the first case that you learn when you start studying company law, really is authority for the principle that a company is not some sort of agent for its shareholder. This was a company which was set up by a successful individual, a trader who sold his business to the company. The company then had 7 shareholders who were all his friends and members of his family, because under the statute at that time, you had to have a minimum of 7 shareholders in any company. At page 9-30, page 51 of the report, Lord Macnaghten explains the effect of the company being incorporated. And he says, when the memorandum is duly signed and registered, though there be only 7 shares taken, the subscribers are a body corporate capable forthwith, to use the words of the enactment, of exercising all the functions of an incorporated company. Those are strong words. The company attains maturity on its birth. There's no period of minority, no interval of incapacity. I cannot understand how a body corporate, thus made capable by statute, can lose its individuality by issuing the bulk of its capital to one person, whether he be a subscriber to the memorandum or not. The company is at law a different person altogether from the subscribers to the memorandum. And that's the key point of the case, that it is a different person from the subscriber and has a distinct legal personality. That was the mistake that the first instance judge and the Court of Appeal had fallen into in Salomon and Salomon. But then if you go forward to look at page 9-33, you can see here that what is being addressed is, and I'll make this good in a second, but you can see that what's being made here was an argument by the respondent on a cross-claim or a counterclaim. It was an argument about fraud. Starting at the top of the page of the report 54, one argument was addressed to your lordships, which ought perhaps to be noticed, although it was not the ground of decision in either of the courts below. It was argued that the agreement for the transfer of the business to the company, from the individual sole trader ought to be set aside because there was no independent board of directors and the property was transferred at an overvalue. There are, as it seems to me, two answers to that argument. In the first place, the directors just did what they were authorised to do by the Memorandum of Association. There was no fraud or misrepresentation, and there was nobody deceived. In the second place, the company have put it out of their power to restore the property which was transferred to them. So in this case, it was suggested that when the sole trader sold the business to the company which he had just incorporated, the property was transferred at an overvalue to the company. But the company's shareholders were all was the trader himself and his family, and the directors, as it says there, were authorized to do that. So there couldn't have been any fraud because the body of people who acquired the business from Mr. Salomon were all completely conscious about the value of the asset that they were being bought, not least because one of the shareholders was indeed the vendor himself. And that is the point which Lord Davey is addressing at page 9-36. This is the part that my learned friend relies upon, but if you read the entire paragraph, you can see that that was the context of the comment that was being made. Totally different question from the one before your lordships. It starts a third of the way down page 57 of the report on 9-36, but Mr. Farwell, who was counsel for the respondent, sorry, my lord.
Hang on, what is it? Sorry, hang on. What page is it you're referring to?
9-36.
Oh, you're still on Solomon against Solomon.
Yes, I'm just
okay.
So
sorry,
I've
I beg
taken
your
you to
pardon.
Lord.
Okay.
I'm taking yes, my lord. I took you to Lord McNaughton just to show the context of this, because here Lord Davey is the law lord who my learned friend relies upon, but it's a slightly different point from the case what the case is normally cited for. So here, a third of the way down of the page, Lord Davey says Mr. Farwell, who is counsel for the respondent, also relied on the alternative relief claimed by his pleadings, which was quite open to him here, namely that the contract for the purchase of the appellant's business ought to be set aside for fraud. The fraud seems to consist in the alleged exorbitance of the price and the fact that there was no independent board of directors with whom the appellant could contract. I'm of the opinion that the fraud was not made out. I do not think that the price of the appellant's business, which seems to have been a genuine one and for some time a prosperous business, was so excessive as to afford grounds for rescission. And as regards the cash portion of the price, it must be observed that as the appellant held the bulk of the shares, or as the respondents say, was the only shareholder, the money required for the payment of it came from himself in the form either of calls on his shares or profits, which would otherwise be divisible. Nor was the absence of any independent board material in a case like the present. I think it's an inevitable inference from the circumstances of the case that every member of the company assented to the purchase, and the company is bound in a matter intra vires by the unanimous agreement of its members. In fact, it was impossible to say who was defrauded. So what the law lord is saying there is that the fact that the board of directors, it was authorised by the memorandum, as you can see from Lord McNaughton's speech, the board of directors was authorised to do that, and not only that, its lack of independence didn't matter because the shareholders approved it, and the shareholders between them would have been the only people who could possibly have been defrauded. So the context of that dicta is this submission from counsel for the respondents that there'd been a fraud and no independent board of directors had considered the price. That demonstrates that actually it isn't as wide a principle as my friend seeks to read, that Lord Davey is there alluding to. Now, if you then look at Geomatic itself, well, actually, perhaps we should pick up my friend's new insertion into the case, which is express engineering. That's at, I think it's tab 13 now. Yes, tab 13, page 1. Now, this is another case concerning the rights of the shareholders and the directors between them in a context of a winding up. You can pick this up from the head note to see that quite clearly. Right at the beginning of the report in the head note, it says a syndicate of 5 persons formed a private company in which they were the sole shareholders and sold to it for £15,000 in debentures of the company, a property which they had a few days before acquired for £7,000. The contract for the sale and the issue of the debentures was carried out in a meeting of the 5, who there and then appointed themselves directors. This meeting was described in the minutes as a board meeting. At a subsequent meeting, the seal of the company was affixed to the debentures. The articles of the company provided that no director should vote in respect of any contract or arrangement in which he might be interested. In the winding up of the company, the liquidator claimed a declaration that the issue of the debentures was invalid and should be set aside. Held there be no suggestion of fraud, the company was bound in a matter inter vires by the unanimous agreement of its members. Although the meeting was styled a directors' meeting, all 5 shareholders were present, and they might well have turned into a general meeting and transacted the same business. In these circumstances, the issue of the debentures was not invalid. So it was the same 5 people, the 5 people who as directors were actually precluded by the articles from voting on this contract because they had an interest in it, were also the members of the company. So this is not a case, evidently, where the members of the company purport to bind the company vis-a-vis the rights, the assets of the company being granted to third parties. Now, I won't take you to the particular judgments of the judges in that case, because the extracts are then cited later in Geomatic and we look at it there. But I simply draw your lordship's attention to the fact that it's a case about the powers and rights between the company, the directors and the shareholders. If we then turn to Geomatic at tab 9, page 38, you can see it is a very similar case because this is a case, if we pick it up at page 9-43, this is a case where 2 directors approved payments to themselves of certain remuneration, but actually between the 2 of them, they were at the relevant time the shareholders. So although as directors they didn't have power to approve their remuneration, they did as shareholders. Now you can see the citation which my learned friend relied upon at F on page 9-43, which is the reference to express engineering works, and my learned friend took you through some of that. But if you go over the page, I want you to just have a look at the passages that are cited quite extensively by Mr. Justice Buckley from express engineering. So at B, Lord Sterndale is cited as saying this: in the present case, these 5 persons were all the corporators of the company and did all meet and did all agree that these debentures should be issued. Therefore, it seems that the case came within the meaning of what was said by Lord Davy and Salomon, and he quotes from Lord Davy. Lord Sterndale goes on: it is true that a different question was there under discussion, but I am of the opinion that this case falls within what Lord Davy said. It was said here that the meeting was a directors' meeting, but it might well be considered a general meeting of the company, for although it was referred to in the minutes as a board meeting, yet if the 5 persons present had said, we will now constitute this a general meeting, it would have been within their powers to do so, and it appears to me that was in fact what they did. And Warrington LJ said it was competent to them, that is the 5 corporators of the company, to waive all formalities as regards notice of the meeting, etc., and to resolve themselves into a meeting of shareholders and unanimously pass the resolution in question. Inasmuch as they could not in one capacity effectually do what was required, but they could do it in another, it is to be assumed that as businessmen they would act in the capacity in which they had power to act. In my judgment, they must be held to have acted as shareholders and not as directors, and the transaction must be treated as good as if every formality had been carried out. And Lord Justice Younger said, perhaps most clearly, I agree with the view that when all the shareholders of a company are present at a meeting, that becomes a general meeting, and there's no necessity for any further formality to be observed to make it so. In my opinion, the true view is that if you have all the shareholders present, then all the requirements in connection with the meeting of the company are observed, and every competent resolution passed for which no further formality is required by statute becomes binding on the company. And the critical part of that dicta from Lord Justice Younger, for present purposes, is the word competent. Every competent resolution, because it is obvious in that case that the difficulty was that the directors themselves were precluded from voting, and therefore, under the articles of the company and the powers given to the members at that time under the statute and the articles of those companies, it was for the shareholders to make that resolution. And the question was whether the shareholders did or not, the shareholders being the same people as were the directors. Now, if you go forward in this decision, you can see other cases relied upon to the same effect, as my own friend pointed out on page 9-49, the Parker and Cooper case and the George Newman and Company case. And then you can see, if we pick it up at C, that Mr. Justice Buckley says, thus the effect of his judgment, that's actually the judgment in Parker and Cooper, the effect of his judgment was to carry the position a little further than it had been carried in Re-Express Engineering Works, for Asbury J expressed the view that it was immaterial that the assent of the corporators was obtained at different times, and that it was not necessary that there should be a meeting of them all at which they gave their consent to the particular transaction sought to be upheld. In Parker and Cooper, as in Express Engineering, no question arose about the provision of any shareholders whose shares conferred no right of attending or voting at general meetings of the company. So that's the progression that originally the position had been they all had to meet together. By the time you get to 1926, the courts have said it doesn't matter if their consent was obtained at different times, as long as they did all consent. And the difference made in Geomatic is that Justice Buckley decided that it doesn't matter that there were some shareholders who had no right to vote who weren't informed about the position. You can see that later in the judgment, but if we carry on and pick it up here at F, you can see Mr. Justice Buckley said, it's not clear from the evidence precisely when that meeting took place, but I think it must be before Mr. Wood joined the board and at a time when Mr. Elvins and Mr. East were the only two directors of the company, and the only shareholders of the company were Mr. Elvins and Mr. East and the preference shareholder. No attempt has been made to show that the preference shareholder ever knew anything about the remuneration of the directors or their drawings, or about any of the matters with which I'm concerned. And it follows, of course, that no attempt has been made to show that the preference shareholder agreed to any of those matters. Mr. Wright for the liquidators contended that where there's been no formal meeting of the company, reliance is placed upon the informal consent of the shareholders. These cases indicate that it's necessary to establish that all shareholders have consented. He argues that the preference shareholder is not shown to have consented in the present case. That requirement is not satisfied, and the assent of those shareholders, that is to say Mr. Elvins and Mr. East, who knew about those matters and who did approve the figures relating to them in the accounts for the year ending April 30th, 1963, is of no significance. And that is the point that this case decides, that it didn't make any difference that there were preference shareholders who would have had no power at all to make any decision. So that is actually the ratio of Geomatic. And again, you can see that that case has nothing to do with any rights which are said to have been acquired by third parties. Simply a question of whether the directors, whose remuneration was claimed back by the liquidator, could rely upon their own decision when they were not just directors but also members. So the members are taken to have approved the directors' decision to grant themselves that remuneration. The same is true of multinational. Multinational gas is a case concerning a company which was set up in Liberia by three multinational oil companies. The company which was set up in Liberia was set up just to do the bidding of these three different oil companies. But then after that Liberian company went into liquidation, its liquidator purported to sue the oil companies, saying it was your fault that this company went into liquidation and conducted these trades. And all multinational gas is concerned with is whether it is open to that company in liquidation to sue its shareholders in circumstances where actually the shareholders are the ones making the decision. And that, and I haven't taken you to it, but I don't think this is going to be contentious. It's a very well-known case. That case has nothing to do with third-party rights. Again, it's just to do with the question of the rights as between the shareholders and the company itself. Now, then perhaps I can look very briefly at EIC. I'm going to come back to Meridian, I think. But in EIC, my own friend relies upon the first instance decision. It went to the Court of Appeal, but I accept that the relevant point is dealt with by the first instance judge, Mr. Justice Newberg, as he then was. At page 9-64 is the report. And you can see right from the beginning at paragraph 1 of the judgment, 9-65, Mr. Justice Newberger says in his introduction, this judgment concerns certain preliminary questions which are directed to the validity of bonus shares issued, paid up by appropriating a sum in the share premium account by EIC Services, the company, on the 15th of December 1999. The argument that the bonus issue was wholly or partly invalid is based upon the propositions that, one, a very substantial number of the bonus shares were allotted to the shareholders whose shares were not paid up. Two, the issue of bonus shares was not approved by a resolution of or otherwise authorised by the shareholders of the company. And three, in these circumstances, the bonus issue and the allotment of some of the bonus shares were invalid and void. And it's the second issue that we're here engaged with. You can see that from paragraph 2, because 5 lines down, Mr. Justice Newberger says issue 2 involves questions of fact and law, principally relating to the applicability of the so-called Geomatic principle. And then if you go forward in the judgment to paragraph 120, which is at page 9-92, you can see that what the judge here records is that it was common ground between the parties that before the 3 directors could properly have approved the issue and allotment of the bonus shares, there should have been authorization under Regulation 110 by an ordinary resolution of the 16 shareholders of the capitalization of the relevant sum in the share premium account and of the appropriation of that sum to pay for the bonus shares. So pausing there, again, it's the very same question. The directors have done something which is then questioned by a liquidator, and which they say in their defense was authorized in practice by the members, and therefore the default in their act has been cured by the members' act. That's why Geomatic was relevant in EIC. You can see over the page at 9-93 that the learned judge refers to Geomatic, and I didn't take you to this, but actually it's a very useful summary of the principle in Geomatic. It said there that Mr. Justice Buckley said, where it can be shown that all shareholders who have the right to attend and vote at a general meeting of the company assent to some matter which a general meeting of the company could carry into effect, that assent is as binding as a resolution in general meeting would be. And of course, the proviso is important, which a general meeting of the company could carry into effect. Those are the words that Mr. Doherty always ignores when reading these cases. Because obviously the power has to be there in the first place. There's then the reference to the 1926 case, Parker and Cooper, and an Australian case of Moore in Herman and Simon, a doctrine that formalities may be disregarded if they have been waived by all the shareholders acting in concert who want the same substantial result, which is, of course, with respect, exactly what Geomatic is about. It's about formalities. And then you can see that the judge explains what the essence of the Geomatic principle is in paragraph 322. 5 lines down, the essence of the Geomatic principle, as I see it, is that where the articles of a company require a course to be approved by a group of shareholders at a general meeting, that requirement can be avoided if all members of the group, being aware of the relevant facts, either give their approval to that course or so conduct themselves so as to make it inequitable for them to advance that they have given, for them to deny that they have given their approval. Whether the approval is given in advance or after the event, whether it's characterised by agreement, ratification, waiver, or estoppel, whether the members of the group give their consent in different ways at different times, does not matter. And what this case turned on was the consent being informed, because actually what happened here was that the shareholders weren't told that this was an action which they needed to consent to, and which they were being asked to approve. So as they were unaware of the facts, they couldn't be said to have given their consent. You can pick that up. There's analysis of it over the next few paragraphs, I'm not going to read, but if you go to page 9-95, page 132, you can see the judge's conclusion. He says, accordingly, I'm of the opinion that each of the 13 shareholders was told on the telephone of the projected bonus issue and its general effect before the 15th of December, but that there was no question of their consent being sought or given in these telephone conversations. And if you look at the next paragraph, it says, if a director of a company informs shareholders of an intended action or a past action on the part of the directors in circumstances in which neither the directors nor the shareholders are aware that the consent of the shareholders is required to that action, I do not think it's right, at least without more, to conclude that shareholders have assented to that action for geomatic purposes. As a matter of both ordinary language and legal concept, it does not seem to me that in such circumstances it can be said that the shareholders have assented to that action. The shareholders simply being told about the action or the intended action on the basis that it is something which can be and has been or will be left to the directors to decide on, and no question of assent arises. And he takes comfort from the earlier cases that support that analysis. So that is the decision in that case. This case was overturned on appeal, but on a completely different basis. But again, it's not a case patently about third-party rights. It's a case about whether shareholders can be taken to have ratified or approved some act taken by directors that they didn't have the power to do. CBAN and Sitco at 9-125 is a case of even narrower focus, because in this case, CBAN, which was, as Monin said, the successor to Spectacular, the company in question, sought to sue its director. So the company was suing its director for something which the director had done on instructions from a man ostensibly authorized by the shareholder. So the complaint on the part of the company was, you should not have done what effectively I told you to do. That's the effect of CBAN and Sitco, because it was the company that was suing the directors. Now, actually, the third party in CBAN and Sitco, there was a power of attorney granted, and the power of attorney, as my friend rightly said, then led to the property of the company being sold. The third party had no complaint, because the third party did acquire the property because it contracted with the company's agent under a power of attorney that was properly granted by the director. The shareholders' complaint in CBAN and Sitco was the director should never have granted the power of attorney. And that was something he was prevented from saying, given that it was his agent, the shareholders' agent, who had in fact asked the directors to do that. So again, it's a case involving the rights and responsibilities between the directors, the shareholders, and the company. I said I'd come back to Meridian, and I do want to have a look at it briefly, but just so you know, my submission on Meridian is that it's not a case to do with this point at all. It's at 9-51. Actually, although Lord Hoffman describes attribution in terms of acts, actually Meridian is primarily a case about knowledge. And that is indeed what it is primarily relied upon to say. You can see that in Lord Hoffman's advice at 9-56. Talking about the New Zealand first instance judge Heron J. Heron J held that Meridian knew on the of November that it was a substantial security holder in ENC for the purposes of Section 24E. He arrived at this conclusion by attributing to Meridian the knowledge of Koo and Ung, who undoubtedly knew all the relevant facts. He did not go into the juridical basis for this attribution in any detail. It seemed obvious to him that if Koo and Ung had authority to enter into the transaction, their knowledge that they had done so should be attributed to Meridian. And it's that question of the attribution of the knowledge to the company that was critical for this case. And it is in that context that Lord Hoffman at page 9-9 goes into the questions about the rules of attribution. Excuse me. Of course, the principles that Lord Hoffman describes are of wider significance, but in the context of this case, that's what he was talking about. But even the wider concepts don't assist Millennium Friend, because if you pick it up at B, you can see that Lord Hoffman says any proposition about a company necessarily involves a reference to a set of rules. A company exists because there is a rule, usually in a statute, that says that a persona ficta shall be deemed to exist and to have certain of the powers, rights and duties of a natural person. But there'd be little sense in deeming such a persona ficta to exist unless there were also rules to tell one what acts were to count as acts of the company. It's therefore a necessary part of corporate personality that there should be rules by which acts are attributed to the company. These may be called the rules of attribution. The critical bit is the next section. The company's primary rules of attribution will generally be found in its constitution, typically the Articles of Association, and will say things such as, for the purposes of appointing members of the board, a majority vote of the shareholders shall be decision of the company, or the decisions of the board in managing the company's business shall be the decisions of the company. Now, pausing there, we respectfully rely upon that primary rule. The primary rules are to be found in the statute and the articles, and I've taken you to both of those, which direct in the case of this company that it is to be the directors, the board of directors, who will manage the business of the company. But Lord Hoffman goes on to say, and this is the part that Millennium Friend relies upon, that there are primary rules of attribution which are not expressly stated in the articles but implied by company law, such as the unanimous decision of all the shareholders in a solvent company about anything which the company under its memorandum of association has power to do, shall be the decision of the company. Now, pausing there, it's an oddity that actually, although it's put in inverted commas, that isn't actually a quote from multinational gas. Now, I don't mean to undermine anything Lord Hoffman has said in his speeches or advice, but actually that is not what multinational gas said. But as I've just shown you, multinational gas was actually concerned with the question about whether a company could sue its shareholders. And what was said in that case was that the shareholders, because they were acting unanimously, could bind the company such that the company couldn't sue the shareholders. So within the context of the dispute in multinational gas, and indeed within the context of the arguments in Meridian, the quote is obvious. It must be the case that those shareholders in a solvent company would be able to bind the company to make a decision of the company as between the company and the shareholder. Lord Hoffman goes on to say, these primary rules of attribution are obviously not enough to enable a company to go out into the world and do business. Not every act on behalf of a company could be expected to be the decision of a resolution of the board or a unanimous decision of the shareholders. The company therefore builds upon the primary rules of attribution by using general rules of attribution that are equally available to natural persons, namely the principles of agency. It will appoint servants and agents whose acts by a combination of the general principles of agency and the company's primary rules of attribution count as the acts of the company. Now, that's what that case deals with, and it isn't the position in our case. Boustard and Reynolds, the textbook that Millennium Friend relies upon, is actually quite clear in making the distinction express. If you look at tab 11 page 3, tab 11 page 3, the section which Millennium Friend read to you, contains within that section actually the answer to the point. Because although halfway down the page the learned editors of Bastard refer to Meridian, the critical point is in the next paragraph. On this basis, the editors say, the board of directors, when acting to bind the company or authorize others to bind the company, operates as a body of co-agents. Well, so far that's straightforward. Equally, to the extent that some of the functions of shareholders in a general meeting or in giving informal unanimous assent involve participating in decision making on the company's behalf with a view to alteration in the company's legal position, they act as co-agents. So those two sentences simply demonstrate that the general principles of agency apply to both the board of directors when acting as such and the general meeting when the shareholders are acting as such. But then the next part is important. The source of their authority, that is the boards and the members, is the incorporation statute and the company's constitutional documents. It would not follow, however, that everything shareholders or directors do is as agent for the company. Sometimes, for instance, directors may act on behalf of the shareholders rather than the company, such as when acting for shareholders who have received a takeover offer. And pausing there, that is often the case when there are specific powers set out in articles of association or even by resolution, where the shareholders are then authorized to act on, the directors are authorized to act on behalf of the shareholders. Carrying on, it is also the case that in exercising some functions, shareholders act solely in their own interests as principals, for example, in changing the constitution. Normally, directors and shareholders will have actual authority as opposed to apparent authority only when they make their decisions in accordance with the procedures established by the statute and constitution. However, both in relation to directors and shareholders, the court recognized early on that these groups could also bind their companies informally, so long as it can be established that all directors or all shareholders, as the case may be, assented unanimously to the decision being made on the company's behalf. Now, the critical point in this paragraph, which needs to be appreciated, is that it is dealing with two different institutions in one paragraph. It's dealing with the board of directors and it's dealing with shareholders in general meeting. It is saying that the general principles here discussed apply to both, but they don't cut across the other. One doesn't cut across the other. And that's the significance of the words "as the case may be." A company can act informally. A board of directors can bind a company informally. That's Geomatic. So can a shareholder meeting act by the company informally. But what it isn't saying is that one group can bind the other, because they're different bodies of co-agents in the language of agency. And that is the error that Mr. Doherty's submissions fall into, confusing the two corporate bodies, the board of directors and the shareholders in a general meeting. And all the cases which he relies to are concerned with the extent to which, when the board of directors have done or purported to do something which they didn't have the power to do, that is somehow cured by the shareholders acting informally. There's no question about that, but it simply doesn't address the primary question in this case, which is whether the shareholders of a company can deal with the assets of a company and grant valuable rights to third parties themselves, formally or informally. Now, my submission, based on Towster and the John Shaw case, is that patently cannot be the case. It would make operating companies quite impossible. There is one additional case.
Sorry, Mr. Thompson. Can you repeat that? The last part is very critical for me. What did you say just now?
What I said was, so I'm not sure how far you lost to go back.
You were saying that. Just repeat the last two sentences. I know we are getting, but I know you are getting the transcript. But I want to put my mind to what you said just now. The conclusion was very well stated.
So
yeah. So go on.
I'll try to remember. I wasn't reading it, so let me see if I can remember. But I mean, so the point I'm making is that all the cases that my learned friend has relied upon deal with the situation where directors have purported to do something which was out with their power as directors, but then they have been able to rely upon the informal approval of the body of shareholders to cure the defect.
Okay.
There is no case. Sorry.
Sorry, Mr.
Yeah. Yes, go on.
Thompson, does that equate to a proposition that common law rules of attribution, which Mr. Doherty relies upon, may be good for issues between shareholders and directors, but are constrained in some way in relation to attribution for the purpose of third-party rights by the division of responsibilities under the Articles or Memorandum of Association and so forth?
I'm not sure I'd put it that way with respect to your lordship.
Yeah.
It's not that they're constrained, it's that the primary rules still have primacy. So one still goes to look to the statute and the articles in the first instance. The gloss that's put on that by the common law is such that it allows a certain degree of informality, which the articles or the statutes might not themselves permit.
Yeah.
But what the common law does not do is completely erode the division of powers that are set out by the statute and the articles in the first place. That would be effectively to say, well, there's no point having articles of a company in the first place.
Yeah. Okay, understood. Thank you.
So really, it's the primacy of the written constitution of the company and the statute of the land that must be taken into account. It could never be the case, of course, that the common law overrides the statute, and it could never be the case that the common law simply ignores the articles of the company altogether. The common law simply ensures that maybe a slightly unnecessary element of formality, which was found within the articles, could be relaxed in order that justice is done.
I think under the bill, there's a statutory remedial provision, as in Australian company law, for informalities or irregularities in decisions of whether they be boards or shareholders. And I think
yes,
in this case.
Absolutely, but of course that isn't this case, because there's no question here of there being some sort of informality which took place that needs to be cured. Oftentimes the court is left to discretion in those regards when it would be unjust to stand on principle in the informality. In fact, the case I was going to take you to does deal a little bit with exactly that point. Because the new CDOS case is a case where there was a reliance in one of the many arguments put before the court by the counsel in that case. There was a suggestion that the provision within the articles curing any procedural error could be used, and it is shown, the limits of that principle is shown in the new CDOS case. I'm just looking to see where it's made into the bundle, and yes, it's 12 tab 5. Now, this is a case which I don't think either party have referred to in their written submissions, and that's my fault. It was relatively lately identified by me. It's a decision of Mr. Justice Oliver, a great company lawyer himself, later became the law lord, of course, dealing in the Chancery Division with a question of company law, with two extremely experienced company law counsel in front of him. And the question, it's quite a complicated situation, which I'm not going to go into, but the question fundamentally came down to
I beg your pardon. Sorry, can you tell me the page again? 5.
Sorry, it's 5 sorry, no, it's my error. Tab 12, page 116. Sorry,
116.
I gave you the wrong reference. I apologize.
Okay. 116. Okay.
But in a nutshell, this is a case where there was a small private company where all the shares were held by two brothers, and one of the brothers died, and he left his widow, who took some time to try and take out letters of administration for her late husband. And then some years later, the widow remarried, and the question was whether her new husband could have the shares transferred to him or not. Now, the interesting part about this case is the functioning of the company between the time when the brother died and the time when the new husband came onto the scene. What happened in that time was that obviously there was only one member of the company alive, and there was only one director, and that was in breach of the particular articles of association of that company. And in particular, there was a rule that there had to be a quorum of two for the transaction of any business by directors. Now, there were various arguments which were rolled out by the unsuccessful company in this case, or the continuing director and shareholder, but the only submission that's relevant for the present purposes is what I think is a second alternative at page 813 of the report. So in your bundle, it's going to be 12-132. And I'll pick it up at C. This is a reference to Mr. Potts' submission, and Mr. Justice Oliver says, I turn then to his alternative submission, which is this. On the death of the deceased, he says, Mr. J.N. Green, that's the surviving brother, was the only shareholder entitled to attend and vote at general meetings. At the meeting at his house in November 1974, that's obviously a typo in the report, it should be 1972 for what it's worth, he, as the only person entitled to attend and vote at the general meeting of the company, assented to his own re-election as director. This was effective, said Mr. Potts, because the case of Geomatic establishes that where all the shareholders entitled to attend and vote assent to something intra vires, the company is bound by that assent, even though it may not be given at a properly constituted meeting. From this proposition, Mr. Potts establishes a train of transactions, all intra vires, assented to by Mr. Green Senior up to the time of his death, and thereafter assented to by all the registered shareholders entitled to vote, attend and vote at meetings, which leads, he says, inevitably to the conclusion that when Mr. Greenan's application for registration was made, there was indeed a validly appointed board of directors to consider it. This I find a startling submission, for it means this, that once the number of registered shareholders has been reduced to one, that one can continue the business of the company and effectively bind everybody else who is interested in it by anything to which, in his private thoughts, he cares to assent. Perhaps that is what Wordsworth meant by the self-sufficing power of solitude. I recognise, of course, that in re Geomatic goes a long way to establishing the power of the corporators to bind the company without formal meetings, but I'm bound to say that I find it difficult to believe that Buckley J, or indeed any of the judges who decided the line of cases from which Geomatic stems, contemplated that the constitutional requirements of the articles could be ignored by the sole shareholder and the company be bound by the lonely soliloquies of the person who happened to be the sole survivor of the registered shareholder. I do not think the Geomatic case is authority for such a proposition. And you can see at the end of the page, the judge refers to Re-Express Engineering and indeed Parker and Cooper. And then he goes over the page to cite the critical part from Geomatic. And I'll pick up again what Mr. Justice Oliver says at F, but I do not see how that helps Mr. Potts in the present case. In the first place, under clause 134 of Table A, Mrs. Green, as the personal representative of the deceased, was entitled to receive notice of a meeting. She did not. That's common ground. Secondly, and perhaps more importantly, the ratio of Buckley J's decision is that where that which was done informally could, but for an oversight, have been done formally and was assented to by 100% of those who could have participated in the formal act, if one had been carried out, then it would be idle to insist upon formality as a precondition to the validity of the act, which all those competent to effect it had agreed should be effected. But as I see it, this necessarily rests on the postulate that the persons assenting were in fact competent to effect the act to which they have assented. There's nothing whatever in the decision which justifies, much less compels, the conclusion that if they were not competent to do it formally at a meeting, that they could do it informally without a meeting. This, I think, is implicit in Buckley J's reference to assent to some matter which the general meeting of the company could carry into effect. And indeed, this becomes even clearer if one looks at the case of Re-Express Engineering, upon which the decision is based. I think I can content myself with two short passages from the judgments of Lord Sterndale and Warrington, and you see there those passages set out, which I've already read to you. And then Mr. Justice Oliver continues, now here there was no capacity in which Mr. J.N. Green Jr. could do what he purported to do, because he could not constitute a meeting, and the line of authority based on Lord Davies' statement in Salomon, that a company is bound in a matter which is intra vires by the unanimous agreement of all the corporators, can have no application in this case. For Mr. J.N. Green Sr., although he was the only registered shareholder, and I pause to observe a minority one at that, was not the only corporator. So the point being made here is that if you haven't got the power in the first place, you can't somehow grant yourself the power, put yourself up by your bootstraps, as my Lord Justice French said, simply by virtue of the Geomatic principle. There needs to be some power vested in you in the first place. In this case, the problem was that there was only one living shareholder, and it wasn't, so that shareholder on his own didn't have the power to bind the company in deciding the appointment of other directors, because he wasn't quorate, and he couldn't rely upon the principle in Geomatic by saying, well, the only other member of the company is dead.
How is this case relevant to our present case?
This case is relevant to the present case because it demonstrates quite clearly in this context that Geomatic cannot be used to grant to members, even unanimously, some power which they don't have in the first place. As for the, I haven't broken my submissions down into the first two building blocks that my friend sought to engage with, because in my submission, those two building blocks rather miss this critical point. But as for his third building block, that is not an issue which in my submission your lordships need to engage with at all, because, as I said, I'm happy to concede for today only, for the purposes of this application at least, that Abdullah did have the power of attorney wide enough to deal with all the interests of Majid and Muhammad as shareholders. So I am happy to concede for the purpose of today that if Muhammad and Majid had the power to bind the company vis-a-vis third parties, then so could Abdullah. That's a point that might be taken up later, but in my submission, it can simplify this appeal because it doesn't assist the primary question of whether Muhammad and Majid actually had the power in the first place. And my respectful submission, they quite clearly did not. And the power of attorney cannot improve that position, obviously. My lords, if you just bear with me for a second, I think I have completed all I wanted to say on this, but obviously if I can assist your lordships on any other issue, I will happily do so, but also let me check. Oh, perhaps I should have brought your lordship's attention, it's in the supplemental Skirson argument, but I should say expressly that the principle explained by Mr. Justice Patton in Towster and relying on the John Shaw case that I took you to has been approved at the highest level in England in the Supreme Court as recently as 2020, maybe might be 2019, but the report's 2020, and by the Court of Appeal in England in 2018. So there's no doubt that that principle that is based on early 20th century authority remains good law in the 21st century. That is because, for the most part, the statutes and the articles of association of companies have been substantially the same on this point for all of those 150 years or so. And so the John Shaw principle is one that has been cited and approved. John Shaw itself, I should have said, is a difficult case to understand because three different judges, although they agreed in the outcome, all used different routes to get to the same point. So it's really Lord Justice Greer's comments in John Shaw that are the relevant ones, but they are the comments that have been approved and upheld by the Supreme Court and the Court of Appeal in England, so giving arguably greater authority to that speech.
We should have gone to the Supreme Court straight away. You didn't have to read the Court of Assistance.
Well, the reason I didn't do that is because the Supreme Court only cite the case and don't go into any of the details. That was actually a much more complicated case where this was a very peripheral issue, and it was mentioned by Lady Arden in passing.
So it was cited rather than he was approved. There was no appeal. There was no proper appeal. It was approved in another case.
Exactly. I can show you to that. I can take
okay.
that very quickly.
It's okay.
Let me show you very quickly. It's at 12-27 or 12-28. The case is a very complicated question of charity law. But if you pick it up at 12-28 right at the top of the page, you can see that Lady Arden simply says some matters, however, require a resolution of a company in general meeting, including the approval of payments to directors for loss of office under Section 217 of the 2006 Act. The members cannot interfere with the decisions of the trustees unless they amend the articles to enable them to do so. And there's the citation of John Shaw. So the principle is approved, but without any great explanation. And perhaps now you've taken me to this and reminded me of this, I should make clear that there are limited circumstances in which the members can interfere. And the limited circumstances are they can amend the articles, and that changes the power of the directors because the power of the directors derives from the articles. So members could resolve to change the articles, and once they've changed the articles, then of course the power balance between the directors and the shareholders might change. Members could also act when the shareholders are when the directors are deadlocked. That's the case of Barron and Potter that we cited in the supplemental Skesna argument that is dealt with in the evidence, and there may well be, though this is a moot point, there may well be cases where the shareholders can pass a special resolution or a unanimous resolution which specifically directs or requires the directors to do something. Now, my own friend, I think, sometimes lights upon this point, but of course that didn't happen in this case, so it's entirely moot. The significance of this point is simply to show that the members might have some sort of power of control over directors, but what they don't have is some power to deal with the assets of the company with third parties without the directors even being informed of that. And there's good reason for that, because there might well be circumstances where the members require the directors to do something, but actually the directors, because of their fiduciary duties, would be obliged to say no, and if they were forced to do it, would resign. So, for example, if the members said, we want you to carry out this transaction, and the directors realize that that transaction will leave the company insolvent, then the directors would be under an obligation, a fiduciary obligation, to say no. So there are, in the real world, there are circumstances in which the members' direction to directors can be resisted and has to be resisted by directors. Equally, there might be cases where the shareholders want to do something which is not bona fide in respect to the company, and the directors wouldn't be or would be in breach of their duty to do so, because of course the directors do have fiduciary duties to a company, even if the shareholders don't. So that's another reason why this principle can't possibly assist my learned friend in this case. It didn't happen, and it's not a universal truth anyway that members can direct the directors to do and simply have them do their bidding. They're not, as it said in those cases, just servants of the company. They have that fiduciary element to their role as well. I think I've dealt with all the submissions I intended to. Let me just check, as we do these days, that I haven't received a message in the meantime. One second.
Sorry.
Yeah. Sorry.
Put simply, you are saying that Abdullah, or the powers where Abdullah had acted, or rather Majid and Abdullah had acted, were not powers of the directors. And therefore,
yes,
the powers that acted were powers of the directors, according to the company law of, or not the company law, the M&A of the company. It is on the directors. So this is powers of the directors, it's not powers of the shareholders, and therefore they cannot do what they did as shareholders. In simple terms, that's what.
Yes, well, absolutely. What they cannot do, to be more precise, is they cannot grant an actionable right to a third party.
Yes.
So we are here dealing with a fiction for the purposes of this appeal, that IGPL is a third party. If IGPL cannot claim to have obtained some valuable property right granted to it by shareholders rather than by the directors. That is, in a nutshell, the main point.
Okay.
I'm just reminded that obviously on the appeal, as this is against an immediate judgment of the judge below, the question obviously is whether there is an arguable case. I think you addressed this with my learned friend. However, we accept that this is quite a narrow point of law. It is possible that it will have to be revisited depending on how, if your lordships allow this appeal, it's possible that it could be revisited, because all your lordships would be deciding would be that it was arguable that Mr. Doherty was right, and it might be that your lordships take the view that fuller explanation ought to be dealt with at trial. But if your lordships are content that you've had a full exposition of the law, then in my respectful submission, you're certainly empowered to dismiss the appeal. And if you allow the appeal, the question will be whether there is then a reasonable prospect of success for Mr. Doherty to advance these points in the light of all the facts at trial. But I think that point is probably something that Mr. Doherty and I are agreed upon in light of his answer to your lordships earlier.
Yeah, because it goes to trial and you are reopening all the facts again.
Yes, well, I mean, I strongly suspect that if we go to trial, the main focus of the trial will be whether this is actually an agreement that was made at the time in 2013, or whether it's been manufactured subsequently to avoid the painful effects of execution against Majid and Muhammad's assets.
Yeah, for this appeal, you're taking the facts as contended by by Mr. Doherty, facts on that. They were just arguing the law.
Yes, well, put it this way: we're not cross-appealing the learned judge's finding about sham. The learned judge said that the question of sham would have to go to trial. It's a classic question that needs evidence. And obviously, Mr. Doherty and his clients will be putting forward Abdullah and Muhammad and Majid to answer questions about how that document came into being if we go to trial. And that question's not something I invite your lordships to consider. We are dealing with it today on the limited concession. This is a valid agreement.
Okay, you understand that. So, Mr. Doty, you ready to reply? How long are we going to take?
I don't think I'll take very long. I know council often say that, but I would hope to be well under 30 minutes. I don't want to commit to 15 minutes in case it's
not more than 30 minutes. Not more than 30 minutes.
Not more than 30 minutes. I had in mind it was going to be about 15, but I know that Justice Giles in particular always says double it. but I'll try my best.
Okay.
The first point is this point on Section 109 of the Companies Act and some of the authorities referred to in the supplemental skeleton for the respondent. Effectively, the suggestion is there are provisions of BVI law and statute which say that a company must act through its directors. But equally, the Geomatic principle applies in the BVI. Sivan was a BVI case, and as such, it is a rule of law in relation to the primary attribution of acts to a company. So it's something which, in fact, sits alongside, and in my submission, is equal to those statutory provisions. And in fact, that is a point which was made clear in Siban at paragraph 39. I'll pull it up quickly. It's at page, so tab 9, page 142.
9, page 142. Okay. Page 142. Okay.
And the extract that I'm looking at here is between B and C. So the context in which Siban is dealing with this is an argument which was raised under Section 80 of the International Business Companies Act. Effectively, what that provision said is that a company can only dispose of more than 50% of its assets if authorised by the directors, and that was a matter of statute in the BVI. And the decision in Siban on that case is this. It says that the Geomatic principle can be applied not merely where the requirement for formal approval derives from the company's articles, but also where it derives from statute is demonstrated in Ocean Rose Investments.
Yes.
So the point was argued and rejected in Siban that those provisions of the BVI's statutory law were overriding on the Geomatic principle. And in fact, that's a submission that the respondent has already made at first instance in this case. I'll give you the transcript reference. I don't mean to take you to it, but it's a tab 8, page 75, which is where the beginning of this argument.
What you're trying to say.
But what the judge has already.
Before you go to that, can you conclude? You make statement that this sentence here is relevant to your case. What is the relevance and what is the conclusion to that?
Yeah. So if we go to bundle 1, page 25.
1, page 25. Yes.
This is an extract from Justice Giles' judgment in first instance in this case, where he accepted the argument that Geomatic applied despite the existence of those statutory provisions. So what he says at paragraph 44 is, I do not think the article or legislation is a sound foundation for this submission, as they are concerned with the division of decision-making functions, and under the Geomatic principle, the division of functions would be subject to decision of the shareholders in general meeting, and said that Siban is against the defendant's reliance on the legislation. What we say is effectively this point on Section 109 of the Companies Act is a different iteration of the same argument. It's saying that the BVI companies have to act through their directors because that's what the statute says. But the point of Geomatic is that it applies irrespective of what those statutory provisions say. And it is another example of a primary rule of attribution. So it sits alongside.
Applies notwithstanding the company rules, company law. Is it?
Yes, what we say is that Geomatic is a rule of law in the same way that the statute provides a rule of law, and it's not subservient to that.
Okay, not subservient to the act.
It's an odd constitutional principle.
Okay.
I don't think it.
They're raising a different point. The point of Geomatic is you're empowering the shareholders to do under the company's memorandum what would be a valid act of the company, and that would be attributable to it. And then the second issue is how do the Articles of Association say that the ordinary management of the company should be carried out by the directors. So they can sit alongside and do sit alongside one another, we say.
Well, the application must depend upon the construction of the statute and the articles. It can't just displace them.
Well, the converse is equally true. That the decision in Siban was that those statutory provisions did not displace the application of the Geomatic principle.
That might be a question of construction, but one might look at the particular set of powers or requirements that the statute outlines and ask oneself the question, is this of a character that, having regard to its purpose and function, is not to be overridden by a rule of attribution?
I mean, it's been repeated in so many cases that it must be a competent power. Competent power, it must have.
Yes, and I will come on to that idea of competent power, because there obviously is a difference between the parties. And in fact, that is really the crux of the submission. The appellant says that it was a competent power of the shareholders to bind the companies vis-a-vis third parties, and the respondent says that it wasn't. That's sort of where fundamentally our disagreement in principle arises. So that's dealing with the point on the provision of the statute. The second point of reply was more of a practical one. The example was given of dealing with the directors on a Monday and dealing with the shareholders on a Tuesday, and that being terribly unworkable, because what would the court have to say about that? Well, two ways of analysing that. The first and obvious answer in my submission would be that it would be entirely open to the court to say that the company was bound in both transactions, and it would be for the court to decide what the consequence of that is. Obviously, if you've got a prior agreement which is valid with another party, it might say impact upon the availability of specific performance as a remedy for that issue, but it doesn't necessarily mean that the company couldn't be held liable by both acts, say in one instance in a claim in damages. The thrust of my learned friend's submission was that it would produce an absurd and unworkable issue for the courts, but it's not typically the practice of the courts to shy away from difficult questions like that. One could also see, for the avoidance of doubt, similar situations arising where you've got two directors, each individually appointed to exercise the powers of a company, and going off on a Monday and Tuesday and entering into inconsistent agreements. The court would have difficult questions potentially about that state of affairs. Similarly, there could be a non-director but an otherwise authorised agent of a company doing the very same thing. And the question of whether or not they're bound vis-a-vis third parties may well be a difficult question for the court, but it's one that the court would be well placed to answer in much the same way as this would be one that the courts could answer in this case. The third point is dealing with, at a relatively high level, some of the authorities cited in the supplemental skeleton argument. That's the Towcester case and other authorities. And the simple point we make about that is that these cases are talking about a different set of circumstances entirely to what's presented to the court in this case. Those cases, or Towcester, is about whether the company or its directors owe duties to shareholders. And it also says that numerical majorities of shareholders can't by resolution impose their will on the directors, where it's the directors who are empowered under the company's articles. I don't think that there's necessarily a disagreement on that point. I referred earlier, this case wouldn't be before the court if Majid and Mohammed had a 99% shareholding in the company, but they don't. Together, they 100% own the shares in the company. And what the law says is that there is a special rule which applies where you have 100% of the shareholders assenting to some particular course of action. And the fact that there are exceptions to those rules of law set out in the supplemental skeleton is something which my learned friend accepts, albeit that he says they're a narrower category of exceptions. But what we say is that the cases cited don't really go to the point, and the point is simply whether or not shareholders acting together with 100% of the shareholding can bind the company vis-a-vis third parties. The fourth point I have relates to some of what was said about the express engineering decision. My learned friend took you to the head note from that case. I'm not sure that the submissions necessarily addressed their lordships in that case ratio in the decision. And we said the reason for that is because it raises a difficult proposition for the respondent, which it will, for obvious reasons, struggle to deal with. The respondent's position up to today has effectively been that shareholders can't make a decision which binds the company and purports to deal in some way with its assets. We say that that's precisely what express engineering says can happen, and no reason is given as to why that disposal of a company's interest or part of a company's interest in a piece of property is any different when you give it to individuals who happen to be shareholders, or whether that property is disposed of by transacting with a third party. We say that there's no material difference there whatsoever. The point is that the shareholders' agreement is an act of the company and is an act which is binding on the company irrespective of where the property ultimately ends up. For example, one could envisage a scenario very similar to the case in express engineering, where one has the 5 shareholders making a decision that the company is going to purchase property and issue debentures, but instead of the debentures being to the benefit of the shareholders in their personal capacity, some property is transferred to 5 separate holding companies, each of which is then beneficially owned by the shareholders. Now, we say that on the application of the principles in that case, the outcome would be the same, even though the property will have been transferred, or the interest will have been transferred to what is effectively a third party, albeit a third party entity beneficially owned by the shareholders. So as a point of principle, it doesn't make, we say, any difference, and that's the authority that is carried by express engineering.
I don't think that's an issue. It's not an issue.
No, it's not an issue. I think it's just to set out a hypothetical scenario in which one could readily see express engineering having a slightly different set of circumstances. I mean, the practical reality is that the reason many of these questions that come before the court have to do with internal dealings between directors and shareholders is because it's the liquidator in the process of unwinding historic transactions who often tries to get money back from what it considers to be unfair dealing between directors and shareholders of companies. So there is an obvious answer as to why the majority of these cases don't deal with third parties, because no one's going before the court trying to reverse those transactions.
But here, the receiver, liquidator, is saying that you entered into this sham agreement to avoid such circumstances, such avoid your property being seized by the bank. Basically, that's the contention. Yeah. Anything else, Mr. Dot?
Yes. Let me just check if there was another point on that. Yes, I think my learned friend had also sought to suggest that there was a distinction in express engineering because the shareholders in that case made the decision in accordance with the company's constitution because the directors couldn't. That's not, in fact, the proper analysis of the case. The provision in the articles wasn't if the directors can't act, then the shareholders must act. What the analysis was in that case is that in circumstances where the directors couldn't act, thereby rendering what they thought was their decision as directors invalid, it was the application of Lord Davies' principle in Solomon that rescues the transaction. So it's not a transaction which is in accordance with the articles. It's a transaction which is based on the application of the rule of law in Solomon, which says that shareholders acting unanimously can bind the company. One of the questions asked by your lordships related to whether the company's laws, whether the laws of attribution or the rules of attribution in respect of companies only make proper sense when one looks at it from the standpoint of it being internal to the company rather than external and dealing with the company's act with respect to third parties. And my learned friend said that he didn't consider those rules to be as constrained in that as that. And what we say is that implicitly means that they can apply and do apply to companies' dealings with third parties. But his answer to that is to say that the primary rules still require one looking to the statute and to the articles in the first instance in order to derive who has the power to do what. But our response to that is that the acts of directors under the articles is only one of the ways under those primary rules of attribution that a company can be deemed to have acted. It isn't correct to suggest that that is by any means the first port of call. Otherwise, Geomatic would not be one of the primary rules of attribution. And that's what the law says that it is. What the law says is that shareholders acting unanimously can do anything that the company can do under its memorandum. And there are some narrow exceptions to that, for example, in cases of fraud, or where there's an exercise of an act which is ultra vires, meaning it's something that the company could not do under its memorandum. And we say that examples of that in this case would be things like the BVI companies carrying on business in the BVI, because that's something which the company's articles expressly prohibit the company from doing. But that's not the case when it comes to the company simply dealing in its own property. The final point is really a short one on New CEDOs. New CEDOs case referred to at the end of my learned friend's submissions. We say that it's a first instance decision which isn't really relevant to the issues in dispute in this case. The point in that case is that Geomatic doesn't apply unless you have all of the corporators assenting to a particular act. That wasn't the case in New CEDOs, but it is the case here, or at least as part of my learned friend's concession that it's conceded that if Majid and Mohammed had assented, that Abdullah could have. Unless there's anything I can assist further with, those are the only short points I had in reply. And I think it's been about 15 minutes.
Very timely.
Good, thank you very much. So, Judge Ali, any further questions? Clarification? Judge French?
No, not for me.
Okay, thank you very much. I'm sorry I asked a lot of questions because I've forgotten a bit about the company law. I've not heard a company law case for quite some time. I've some new principles that are developing which are not familiar with. So I apologize for asking a lot of questions. I was learning the law of company law as we went along. But that's what judges do, isn't it? My father was the Chief Justice. Zaki, you never forget that a lawyer in appeal case will stand up and say, "My lord, the burden of proof is beyond reasonable doubt." We hear that every day, 10 times a day. But that is a lawyer's duty to remind the judge what the law is about. So thank you very much indeed. I'm sure hopefully it makes our writing the judgment easier with all the clarifications and submissions given to you. So we will reserve our judgment and we'll let you know when we're ready to deliver our judgment. So judges, can we go back to our judges link to discuss?
Yes, certainly.
Okay, thank you very much,
Thank you.
Mr. Totti and Mr. Thompson. Thank you very much.
Thank you very much.
Thank you.